Good morning. Good morning. It's Thursday. It's April 25th. Lots of legal news today. Some of it breaking this morning, some of it ongoing. It's going to be a busy stream today. There is currently a hearing ongoing in the Karen Reed case. I've been keeping an ear on that hearing in the Karen Reed case. It looks like opening statements will be starting on Monday, and I will be streaming those on Monday. So far, a lot of their arguments are being ruled on like this. Is that going to be on your opening statement? No. Okay, we'll circle back. So the court has basically put a pin in it on most of the things that they are arguing. So that's happening in Karen Reed. If we have time, we'll circle back. I don't know if we will. There's a lot else going on in the law today, including Alec Baldwin's attorneys striking back quite pointedly at the prosecution in the Rust motion to dismiss the indictment. There was breaking news this morning with the New York Court of Appeals overturning Harvey Weinstein's 2020 convictions and ordering a new trial. So we're going to go through that. And there's a few quick matters of quick bits that are going to be quicker than I anticipated the quick bits to be. How quick can a quick bit? So as with regard to Weinstein, I will be covering just what the ruling is from the Court of Appeals. I am not going to get into much more than the underlying law and the ruling. We're not going to get into the underlying facts of the case, argument about facts of the case. We're not going to relitigate the case. My hope is to bring understanding as to what the court ruled and why, because there are lots of feelings about it. I understand the feelings about it. So it's going to be a good opportunity for all of us to try to put our feelings about a person aside and look at what the court did and why. And even if we disagree with what the court did and why, to understand how we got here. And that can be very difficult, especially when emotions are flared, especially with defendants who there's very strong animus towards. And I understand that. And it's okay. I'm not telling you not to have feelings. Have all of the feelings. I'm just asking that as we get through the feelings, we also try to understand what the court did and why, so we can understand really what the court did and why, even when it is hard, because appeals courts are very skilled at being unfeeling. That is what they do. They just look at the transcripts, they look at the law, and they make their decisions. So appellate work can be very, very cold. Truly, it's not. Trial work is very in it, right? You've got the live witnesses in court, the live defendants in court, the live arguments in court. Emotions are very high. By the time things get to the appeals court, emotions have calmed, situations have calmed, and they're just looking at the transcript through the lens of the law, which truly can be very distant. So look, your feelings are valid. I absolutely get it. We're going to try to understand why. Okay, so that's what we're doing with that. Heather in the chat already said trial equals passion, appeals equals reason. Yes, the law is reason free from passion is something that we talk about in one way or another quite often on this channel, and the feelings are okay. So with that, we have a few quick bits. There's been another charge in the Kansas mom's murder case, so we're going to talk about that really quickly. TikTok has been banned. They're going to sue. I'm not going to cover that any more than that. That's about it. If it's needed, we'll get into it. If you're a TikTok creator, it's time to consider other platforms. Maybe we'll do the most minimal of quick bits. Last night, I promised we were going to talk about TikTok more. I don't know if we're going to have time with all the other stuff that's happening today. So we're going to zoom through a few quick bits before we get into Weinstein. And then we will end the day with the Baldwin and the Shade and everybody fighting back and forth and throwing mud at one another. So there will be the harder case. And again, we're not going to get into the facts of the case that can be substantially triggering. And then we will get into the Shade and the mudslinging in the Baldwin case. So that's the plan for today. Let's just roll the intro. Let me know what you're drinking, where you're coming in from. Thank you for being law nerds. I appreciate you. I've got coffee. I've got water. I'm ready to see what I had to hold myself back. I started going through the Baldwin motion. I'm like, no. We're going to do a first look. And so I had to we had to rein it back in. So with all of that, I'm going to roll the intro. And law nerds, I'll see you on the other side.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not. Let's get into it.
All right, we're going to have some quick bits that we need to get to first. If you watched yesterday's podcast, I was covering the case of two Kansas moms who were killed. 4 had been charged. 1 had been named. And in the podcast episode yesterday, I mentioned that individual had been named but had not been charged yet. Well, yesterday after the podcast aired, that individual was arrested and charged. We're not going to dive deeper into those charges. If you want to know more about that individual, CEG yesterday's podcast, but there has been another arrest and there will be a 5th co-defendant there. So let's just go to the AP real quick as we cover this. Oklahoma prosecutors charge 5th member of anti-government group in Kansas woman's killings. Oklahoma prosecutors charged a 5th member of the group, the co-defendants, the conspiracy as charged at this point. Let's go to reader mode real quick. Paul Grice, Grice, 31 was charged in Texas County, Oklahoma, with 2 counts of first-degree murder, 2 counts of kidnapping, and 1 count of conspiracy to commit murder. Same as all the other charges. All of these charges have been the same. 2 counts of murder, 1 for each victim, 2 counts of kidnapping for moving the victims, and then the conspiracy to commit murder for the overarching conspiracy, where they planned to carry out the murder of the victim, the other Veronica Butler. The other victim, Jillian Kelly, was with Veronica and I think was killed because she was with Veronica Butler. And the conspiracy being the conversation happening in advance and the rest of it. So Paul Grice, let's go with Grice, like rice with a G. Let's go with that. Grice is being held without bond. All of them are in Texas County Detention Center. Court and jail records don't indicate if he has an attorney who would speak on his behalf or who could speak on his behalf. All of the other defendants have been appointed public defenders. I imagine, well, public defenders or alternate public defenders so that there is not conflict. I imagine that will be the same here. Alternate public defenders will step in when there are co-defendants, so there's not a conflict with the public defender's office. RDESQ or Rod, sorry, RDOD ESQ asked, is Grice the kid's father? No, the kid's father is not Grice. The kid's father, hold on, I'm gonna have to go back to my notes to find the name of the kid's father, but the kid's Butler's children's father, the son of Tiffany Adams, is not Paul Grice. So that is different. I will pull my notes in a minute and pull that up. I remember the first name being Wrangler. I don't remember the last name. But Rickman, thank you. Denise Adams said Wrangler Rickman. Thank you, Denise. Chad is bae. Chad has my back. We've got it. How Paul is connected to the rest of them, his name came up numerous times. So I'm not sure the interconnection of all of it with Paul, other than his name came up in the other affidavits that we covered yesterday on the podcast. Tiffany Adams is the grandmother of the children, the mother of the children's father, Rickman, her boyfriend, Tad, and then Cole and Cora Twombly, and then now Paul Grice. Butler and Kelly disappeared on March 30th. We know that. A witness who spoke to the Oklahoma State Bureau of Investigation said all 5 suspects were part of an anti-government group that had religious affiliations, according to the affidavit. I'm not putting any words on their name out into the universe. Paul Grice RK asked, is he the person that owns the land where the victims were located? No, he is not. That is a different individual. There are quite a lot of names in the podcast, but no, he is not the one that owns the where the victims were recovered, according to the affidavits. Let me pull up that affidavit real quick and answer that question. Then we will move on, because it was a different paralegal. Eagle Eye said Beasley owns the land, and that is much closer to my memory as well of who owns the land that the victims were found on that was being rented. So you guys, chat is bae because chat has an incredible memory. So yes, that is where it is. But it was, again, Paul was mentioned briefly in those affidavits. And I noted in the podcast that even though he was mentioned, that he had not yet been charged. So that is in yesterday's podcast if you wish to dig a little deeper into that story. But chat, thank you. It is a lot of names. I will make a chart before I cover this case again. I don't know when we will have time. It really is a collective memory. Madry said, I do not have an incredible memory. It's okay. The chat does. Have I made a cheat sheet? I have a list, but I don't have a cheat sheet yet because I just simply have not had time. It's been really, I always say this, Emily, you just are going to keep saying it's been really busy, like until 2029. Yes, probably. TikTok, real quickly. Both parties, here, let me swoop. TikTok's been banned. There's that. Both parties or both houses of government banned TikTok. The president signed it. It requires TikTok to divest or be sold from ByteDance to a company that does not operate out of China. The CEO of TikTok has said, quote, "We will keep fighting for your rights in the courts. The facts and our Constitution are on our side, and we expect to prevail again." This TikTok ban is similar to the one that we are seeing play out from Montana. And I covered that when Montana started taking action against TikTok within their state. That is going up now to the Ninth Circuit Court of Appeals. So there will be the Ninth Circuit case, and then it will continue to roll through the courts as to whether the government banning a social media app is a government restraint on free speech or not, and whether the government's stated purpose of protecting the citizenry is I don't like to say valid, is a way that speech can be restricted. There is a 9-month span for TikTok to divest before this swings into effect. So if you go on TikTok today, is it gone? No, it's not. This is going to be fought over the next 9 months and possibly longer. So can this happen? We'll see. I'm very interested to see how the courts take this up. The First Amendment issues are going to be different in the way they address whether this is a foreign government essentially spying on the US and whether that is an appropriate way to require the company to divest or not. We will see. Here's what I'm saying. If you are a content creator and TikTok is your main platform, it is time to consider alternate platforms and diversify your content creation. I know the dopamine is high. The dopamine is high on TikTok. I understand. I don't spend time on TikTok. I don't have TikTok on my devices. However, That's because mostly it is completely for me, a time suck, and I cannot. Does TikTok gather more information than Instagram, Facebook, YouTube, and others? The lawsuits indicate it gathers some more information than those. That's not to say that Instagram, Meta, Google, YouTube, and everything else don't also gather a substantial amount of information on you. It's just what is done with that information, how that information is used and protected, and whether or not TikTok is using that information improperly. So that's really the heart of the argument. But can the government ban a speech platform? Truly, we'll see. I'm interested to see it play out in the courts. It's going to be a fight in the courts. Previously, the Ninth Circuit had, when California tried, no, it wasn't California. It was also the federal government. The last time they tried to do this with TikTok, there was an immediate injunction to stop any sale or divestment because TikTok was actually looking at purchasers in the US at that time. And the court's like, we don't know if the government can actually do this. So we will see what happens. But there is 9 months. You have the option to opt in, opt out. There are lots of creator economy surrounding TikTok. It was under the previous Trump administration, and there was an injunction then. So this was 5-6 years ago. So this came up quite a while ago, and there was like an immediate injunction where they're like, no, you can't enforce the ban until it goes through the courts and there's process. So with all of that, creators need to diversify their platforms. I realize that the dopamine on TikTok is very high. I realize that there is a difference between how fast a creator can grow on TikTok versus Instagram versus YouTube or other more established platforms. I get it. I get it. However, there is time now. You've got 9 months to start figuring out where you also want to create. It's not going to grow as fast as TikTok, and I get it. It's real fun. It's real fun to watch those numbers go up. I understand. But TikTok's future is uncertain at this point, and this fight is not going away anytime soon. Are there other things to fight about? Yeah. Yeah, there are. But this one's happening. So that's where we're at on TikTok. All right. Any more need to be said? No, we need to move on. Perfect. Great. Quick bits are quicking today. Quick bits are zooming today. Let's talk real quick about Megan Thee Stallion. I got asked quite a lot about the Megan Thee Stallion lawsuit. I'm not even going to pull the lawsuit up on screen at this point because we are going to zoom through this. This is the same attorney who has plaintiffs that are suing Lizzo. There are some salacious details at the beginning of the lawsuit, but those aren't the grounds of the lawsuit. The grounds of the lawsuit are not the salacious allegations at the beginning of the lawsuit. The grounds of the lawsuit is that I'll pull up the Law 360 article because I understand that when there are salacious details in a lawsuit, the lawsuit gets more traction in the media, and that more traction can cause cases to resolve more quickly. Like, I get it, but there's times when it's like, is this even part of the lawsuit? So, Megan Thee Stallion's ex-worker alleges hostile workplace. This is a former cameraman who filed a labor violation and harassment complaint in California state court, alleging the rapper created a hostile work environment by engaging in adult activity in a car, in Ibiza, in front of him, and then fat shaming him afterwards. The 42-page filing from Emilio Garcia says that the rapper whose real name, yes, we didn't think her last name was actually The Stallion, whose name is Megan Pete, improperly classified him as an independent contractor while he worked 50 hours a week as the Savage singer's personal cameraman without overtime, meal breaks, or rest periods. Here's the takeaway on that. though there are details of other things and harassment alleged, this part is going to be a problem. This part is going to be a problem. That's not salacious in any way. That is a problem. Miscategorized employees is an issue. This happens with creatives. It is something that their teams should help them with, but that one's going to be hard. So if he is only working for Megan, and if he is working as a cameraman, and if he is creating content for social media, he might not be an independent contractor. And California's new rules about this are unforgiving to employers at best. There was a new case in California, Dynamax, in 2018. It was codified in 2020. It's one of the things my podcast started to grow talking about was California codifying a different test for independent contractors. I'm not going to go through all of that with you today, but California's rules on independent contractors have caused disruption throughout the entertainment industry and the music industry, the creator economy, and others. This is an issue. And there are some pretty strict penalties in the law if you mischaracterize independent contractors in California. So all the other stuff aside, if this person was a miscategorized employee, not independent contractor, that is going to be a problem. For that reason, Odinente said, don't forget the transportation industry. Huge issues in the trucking and transportation industry. So if that's the case here, I imagine that this lawsuit will settle because there are penalties under the law here. The law is pretty stringent when it comes to these rules. And if he is working 50 hours a week just for her to create social media content, I can see the court saying, well, you're a musician. Social media content is part of what you do for a living, and this person is not a contractor. So I can see that part being a issue truly with this lawsuit. But when you put in these salacious details and the rest of it that's going to make this gain traction in the media, I wonder, does it make it harder for someone to settle this lawsuit? Because if you're, Megan Thee Stallion's team and you settle, what is the concern there? The concern is if you settle it because the employment claims need to be settled, and these types of employment claims happen all the time. If the employment claims settle, does it indicate that you're also acknowledging the other stuff? So does this case actually go away faster if you don't put in all of the other stuff to have this, spread in the media? Or is the belief that the more media attention, the faster it will settle? I don't know. It's interesting because the employment law stuff is something that's going to have to resolve. And if these allegations are true, and if this employee was mischaracterized, there's not much that you can do to defend it. Other stuff you can deal with, but not much can be done with that because of the way California is interpreting their new ABC laws. So the ABC test is something I've covered ages and ages and ages ago. But if you are interested in getting into the workplace and employment law of it all, because that's really what this is a miscategorization employment law, overtime and wage time lawsuit. We can get into it later. Those things are generally resolved. But when you put in details that could embarrass or grab headlines or are salacious, it is my opinion that it can make it harder to settle. So we will see what happens. But the the hour, wage time, break time, miscategorization claims are going to be difficult. So that's what's going on with that lawsuit. But it's not a lawsuit over any of the headline grabbing stuff. It is an employment wage and miscategorization lawsuit at the heart of it. So I got asked about it. That is really the heart of it. But I was going to dive more into it today, but there's other things in the news that have bumped up that I think need more explanation than this. So yes, employment law lawsuits happen. Yes, they are very common. Yes, it is something creatives need to consider. Yes, it is something their lawyers and their team should help them navigate. Yes, it is something that can be a problem. And yes, the state of California can initiate these lawsuits they can initiate fines and penalties on their own. You don't even have to be sued over it. So, Tiffany RX said Meg's lawyer released a statement saying they will deal with the employment issue in court as they should. It really is a wage and hour claim lawsuit, and those settle or should settle. Let's see. The attorneys for the plaintiff said Megan just needs to pay our client what he's due, own up to her behavior, and quit this sort of sexual harassment and fat shaming. That's what the plaintiff's lawyers have said. I'm sure Megan Thee Stallion's, let's see if there's a quote from Megan Thee Stallion's lawyers in here. I do not see one when this article was published, but I don't doubt the chat when we'll deal with this in court. This is an employment law issue that gets dealt with in court all of the time. Literally all of the time. So it's why, companies shuttered in California and left California when these laws changed. It was a huge issue. And then there was a carve out for things like Lyft and Uber. The ripple effect of the change in laws in California is still happening. So, all right. Let us talk about, those are our quick bits. Let us go talk about Weinstein, and then we will talk about Baldwin. Look, I kept the quick bits quick. We kept it quick. We kept it quick because we have to talk about this. So, chat, are you ready? Some of you are like, no, I'm not. No, I'm not. We're okay. It's happening. We're going to talk about it. All right. So this morning, the New York Court of Appeals overturned Harvey Weinstein's 2020 New York convictions. This is not an overturning of the Los Angeles convictions. He has been convicted both in New York and in Los Angeles in California. He was sentenced to 23 years in New York, 16 years in LA. Does this impact the sentence in LA? No, not at this point. Is that case already up on appeal? Yes, it is. So when we talk about other cases like Murdaugh, and people ask, well, if he's been sentenced, not law nerds, because law nerds know, but sometimes people ask, Murdaugh's been sentenced on, the murder case to 2 consecutive life sentences, and then 27 years on the financial crimes. And then the Fed sentenced him to another 50 whatever years, and on and on and on and on. Why do they keep sentencing when there are all of these other convictions? This is why. Things get overturned on appeal. It happens. Does it happen all the time? No. Does it happen often? I would say no on that too. But it does happen. It's why you sentence on multiple cases if that's what's needed, not just the one that's before you, not just on the highest number of sentencing, not just on the first case. It's why you sentence case by case by case. So is Weinstein's convictions or sentence in California changed? No. Is that up on appeal? Again, yes, it is. So let's go through this opinion and hopefully answer some of your questions. I normally do Q&A at the end. I'm going to do Q&A on this before we move on to Baldwin, because I know you're going to have a lot of questions. But when we talk about trials needing to be done right, no matter who the defendant is, trials have to be done right, because having to retry them is a mess. Nanner said he's just moving prisons, correct? If he is being housed I don't know if he's being housed in New York and California. If he's being housed in New York, they will move him to California. If he's being housed in California, he will just stay in California. I don't know where they were housing him. So if he's in California, he stays. If he's in New York, he'll be transported. So, and they will probably, I imagine his defense attorney will make a motion to have him released on the New York, like formally released on the New York case. A formal release on the New York case means he will be bounced into California custody if he's not already there. So we're going to go directly to the court ruling, and then we might go to some media articles on it. We might not. Emily, you're not sharing your screen, girl. Let's do that. Hold on. And then if you are in the app, I sent a link to the New York courts so that you have this, you have access to this opinion and decision for yourself if you wanted to go through it and read it, because I'm not going to read all 77 pages of it. We are going to go through the most pertinent points and then go through the rest of it. Let's see. Mary Evans said, isn't Karen Reed's lawyer also Weinstein's? Yes. Alan Jackson defended Weinstein. I don't know if he defended Weinstein in the New York case. Hold on. I know he did in the Los Angeles case, but I don't remember. So I am noodly Googling. I know that he did in Los Angeles, but truly, I don't know if he did in New York. And I don't see a quick answer to it. So I'm going to have to do a deeper dive into it. I don't know if he did. I know he did in California. So I do not know about the New York trial, but I'll look and see what we see about the New York trial. All right. Let's get into the Court of Appeals and what they had to say. But yes, Alan Jackson, the defense attorney for Karen Reed, was one of the trial defense attorneys for Weinstein in Los Angeles, was a trial defense attorney for Kevin Spacey, and was the prosecutor for Phil Spector. So all of that. Let us go. All right. This is a split opinion. There are a number of judges that are dissenting here. So this is not a unanimous opinion. This is a split opinion. Not everyone on the Court of Appeals who sat and heard this case agrees. Every person accused of a crime, they say, is constitutionally presumed innocent and entitled to a fair trial and the opportunity to present a defense. And then they cite to the Constitution and case law interpreting the Constitution, saying the right to a fair trial is a fundamental liberty secured by the 14th Amendment, and the presumption of innocence, although not articulated in the Constitution, is a basic concept of a fair trial under our system of criminal justice. Whether rooted directly in due process, in the due process clause of the 14th Amendment, or in the compulsory process or confrontation clauses of the 6th Amendment, the Constitution guarantees criminal defendants a meaningful opportunity to present a complete defense. This is quoting Trombetta. For everyone who's been to law school, Trombetta has entered the chat immediately. Under our system of justice, the accused has a right to be held to account only for the crime charged, and thus allegations of prior bad acts may not be admitted against them for the sole purpose of establishing their propensity for criminality. We talked a lot about bad acts evidence when I was covering the Murdaugh case. The financial crimes, and a lot of the financial crimes were bad acts evidence. They're state by state, it's different, and there are narrow exceptions when you can show someone's bad act to show a pattern of behavior, a state of mind, etc. But the general rule of evidence under 404, not found under 404, is that you cannot use prior bad acts to show someone has a propensity to do the thing. It's like, look, they did this thing. So now, because they did that thing, it means they're more likely to do the thing they're charged for. So it's Joe Jersey asked, can prior convictions be used? Prior convictions are very different from prior bad acts. Prior bad acts are not prior convictions. Prior convictions can be used in a much different way, and it's much easier, and it is contemplated by the rules of evidence to use prior convictions. But it depends on the case how those prior convictions get used. He did not have prior convictions at the time of the New York case. So at the time of the New York case, there were prior bad acts that were not convictions that had not been charged. So that is a great question, Joe Jersey. We talked about this in Murdaugh, because in Murdaugh, his character was at issue. And so they were talking about truthfulness. But Murdaugh had also admitted a lot of the financial crimes. So it's different when Murdaugh is admitting the financial crimes and then those are being used, even though there is concern in the Murdaugh case, and this concern has been raised quite a lot in the Murdaugh case, about whether the judge allowed in too much on the financial crimes, even though they were admitted. In the Weinstein case, they were not admitted, and it is different. So that is part of what came up in the Murdaugh case, but there was very much a issue with regard to whether or not too much was coming in the Murdaugh case, and it's something we will see whenever that appeal gets filed. I've seen notice of appeal, but I haven't seen an appellate brief. So I'm holding some of the questions I see so we get through this, and we will go forward. But you guys have great questions. All right, let us continue. Nor may the prosecution use prior convictions or proof of prior commission of a specific criminal, vicious, or immoral act other than to impeach the accused credibility. It is and there are different rules depending on different jurisdictions. California has some very specific carve-outs with regard to sex crimes, different than other jurisdictions, but there are some specific carve-outs. Yes, this is from the case People versus Sandoval. No, not that Sandoval. Yes, we will talk about that Sandoval another day. We are not going to have time to talk about that Sandoval today. The court goes on to say it is our solemn duty to diligently guard these rights, regardless of the crime charged, the reputation of the accused, or the pressure to convict, citing from Boyd versus United States, coming to us from 1886. So for those of you asking about the Magna Carta, we did get to 1886. We'll see if we get back in time any further than that. It is the duty of courts to be watchful for the constitutional rights of the citizen and against any stealthy encroachments thereon. Defendant was convicted by a jury for various sexual crimes against 3 named complainants, and on appeal claims that he was judged not on the conduct for which he was indicted, but on, this is their quote, irrelevant, prejudicial, and untested allegations of prior bad acts. We conclude that the trial court wrongly, admitted testimony of uncharged, alleged prior sexual acts against persons other than the complainants, not the complainants, other than the complainants of the underlying crimes, because that testimony served no material non-propensity purpose. The court, and propensity is the issue. So the court is saying that the testimony of not the victims who crimes were charged to, non-victims who are not the victims of a prior conviction, that testimony, it serves, the court says, no material non-propensity purpose. Propensity being, well, look at all this other shit that he's done. Obviously, he did this shit now. So you need to convict him on this shit now because look at all the other shit. If the other shit is not convicted, then you start getting into the realm of it being a problem. The court compounded that error when it ruled that the defendant, who had no criminal history, we'll just note, had no criminal history, could be cross-examined about those allegations, as well as numerous allegations of misconduct that portrayed the defendant in a highly prejudicial light. The balancing test for this is it more probative than prejudicial? The synergistic effect of those errors was not harmless. The only evidence against defendant was the complainant's testimony and the result of the court's rulings. On the other hand, wait, I got lost in the middle of all those commas. Let me start that sentence over again. The only evidence against defendant was the complainant's testimony and the result of the court's rulings. On the other, on the one hand, was to bolster their credibility and diminish defendant's character before the jury. That isn't. Is it me? That's an awkward sentence. But the court is saying the only evidence against defendants was the complainant's testimony, the court rulings, and they're saying that that was to bolster the credibility of the witnesses and diminish the defendant's character, which is not proper. On the other hand, the threat of cross-examination highlighting these untested allegations undermined defendants' right to testify. The remedy for these egregious errors is a new trial. So the court did not say these are harmless error, which happens a lot in appeals. The court will find harmless error and then go, yes, there's error, but it's harmless. They are saying this is not harmless. This is egregious error. And with that, a new trial is the only option. So a new trial, we will see. There's a statement in one of the articles we're going to pull up. The DAs have already released a statement on this, talking about whether or not they will pursue a new trial, but generally they're going to have to speak to the victims about whether the victims will go through this again and what that looks like. They say that they reject defendant's claim that the third degree prosecution was untimely. We're not going to get into that allegation, but they find that the defendant may be retried on all of the counts. They do a summary of the charges here. They do a summary of the trial here, and go into the detail of that, of the trial and the conviction. We're going to move past that. They say before the trial, the court granted the prosecution's application to admit certain testimony of uncharged crimes and miscellaneous bad acts as an exception to the Molyneux rule prohibiting such evidence, which is also, again, in the rules of evidence, to establish defendant's intent and his understanding of the complainant's lack of consent. So when we look at, we're going to look at Rule 404 real quick. And when we look at Rule 404, we're going to talk about what exceptions there are to this rule, because the court is going to go through them as well. Where is my 404? I am not trying to make a not found joke. It just, it's at the very bottom of this one. Hold on. It's the little rules of evidence. Character evidence, other crimes, wrongs or acts. 404A1, prohibited uses. Evidence of a person's character or character trait is not admissible to prove that on a particular occasion that person acted in accordance with the character trait. That is your propensity. Exceptions for a defendant or victim in a criminal case. This is 404. Wait, did we skip a page? No. This is 404A2. The A2, A, B, and C. The following are exceptions that apply in a criminal case. A defendant may offer evidence of the defendant's pertinent trait, and if the evidence is admitted, the prosecutor may offer evidence to rebut it. So the defendant has some options to offer character evidence if they testify, and then the prosecution can rebut it, but the defendant has to bring it in first. 404 A2B, subject to the limitations of Rule 412, a defendant may offer evidence of alleged victim's pertinent trait. So the defendant may use character evidence of a victim of a crime. If the evidence is admitted, the prosecutor may offer evidence to rebut it and offer evidence of the defendant's same trait. In a homicide case, which is 404-2C, which is not relevant here, 404B, which is relevant here, other crimes or wrong acts, prohibited uses. Evidence of any other crime, wrong, or act is not admissible to prove a person's character in order to show that a particular that on a particular occasion, the person acted in accordance with the character. You can't say just because they've done it all these other times, it means they must have done it this time. Look at all the other shit that they did. Obviously, they're doing that shit now. Permitted uses. The evidence may be admissible for intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. Notice in a criminal case, the prosecutor must, and then it lists all the notice provisions. There are prosecutors who forget to do this all the time. And it's like, but did you give notice? If you did not give notice, no evidence, if you did not give notice of it. So that is why we are now at this point talking about the prosecution giving evidence or giving notice that they were going to seek to use 404B evidence in the Weinstein prosecution. So they say complainant B could testify about defendant's uncharged sexual assaults against her before and after the charged assault, the awareness of defendant's abusive and threatening behavior. And 3 other women, those are the Molyneux witnesses, could testify regarding defendant's misconduct towards them years before and after the charged offenses involving complainants A and B. It's different when you are dealing with the complainant who is saying, these are a pattern of things that have happened to me. One of them is charged, others of them are not charged, is a different circumstance than others where nothing is charged. The court also granted in large part over defendant's objection the prosecution's Sandoval application to cross-examine defendant on a broad range of uncharged bad acts should he testify. Pursuant to this ruling, the prosecution was permitted to ask about, for example, whether the defendant directed a witness to lie to the defendant's wife, filed an application for a passport using a friend's social security number. So some of that's going to truthfulness, told a woman he could harm her professionally, but also could offer her a book publishing opportunity. And then they listed other similar acts and statements on and on and on. After the court denied defendant's motion to dismiss the third-degree charge, which we're not getting into, complainant A testified that she had known defendant since 2004, and then they go through what happened during that time. Let's see. They are describing the testimony and the nature of the testimony that came in, that the defendant would regularly use hotel rooms for those things, and then they talked about the same with complainant C. The 3 Molyneux witnesses testified these are not victims of the crimes charged, but witnesses who had other experiences with him that were non-charged. The 3 witnesses testified about defendant's individual unwanted advances towards them. Witness 1, and then they go through witness 1's testimony, witness 2 testimony, and witness 3's testimony. The court does note that when the defendant was tried in California for conduct against witness 3, the jury failed to reach a verdict. So witness 3 was a witness in New York, but was a victim in the California case. The jury hung twice as to the counts related to who the New York case is calling witness 3. And ultimately, the prosecution in LA chose not to continue prosecuting the second round of hung verdicts. So in California, there were a multitude of charges and a split verdict. Some were convictions, some were acquittals. And we'll get into that more as whether or not his sentencing was enhanced in California due to the convictions in New York. And now that those have been overturned, whether that will be an issue in California. We will get there. Let's see. Talking about the appellate court, let's see. The court sentenced defendant to consecutive terms on each count for an aggregate 23 years, followed by 5 years of post-release supervision. The appellate division affirmed. The court concluded as relevant here that the tolling provisions applied, so that was timely. The court concluded that the trial court properly admitted the Molyneux testimonies to show that the defendant's sole interest in the complainants was sexual and that their consent was irrelevant. Let's see. We're not getting into the third degree case because ultimately they're allowing it to be retried when and if these are retried. And that is a substantial argument on this. Defendant argues that the admission of the Molyneux witnesses' testimonies detailing sexual assaults he allegedly committed against them before and after the offenses, which means the criminal charges that he was being tried for, ran afoul of the case law. We agree that this challenge has merit. Indeed, we reject the prosecution's theory accepted by the appellate division and the dissenters here, which are the other judges, that this testimony showed defendant's state of mind to use forcible compulsion against complainants and his understanding of their lack of consent. The analysis, if adopted, they say, would eviscerate the time-tested rule against propensity evidence, which in criminal cases serves as a judicial bulwark against a guilty verdict based on supposition rather than on proof. So that is really the heart of this decision, that they say the amount of propensity evidence that is not prior convictions, that is prior allegations, ran afoul of the rules of evidence against propensity evidence. And those rules serve as a blockade against a guilty verdict based on supposition rather than on proof. The dissent has very strong words in their dissent about that. Let's see. They then go through the lineage of the case law and the propensity case law, and all the other states that have adopted it. It's part of the federal rules of evidence. This is not unknown. Let's see. I am going through to try to get to the last part of their ruling and determination here. But again, if you want to read the entire 77 pages, it is in your messages in the Lawnerd app. Let's see. They say, in reaching this legal conclusion, we take no, quote, step backward from recent advances in our understanding of how sex crimes are perpetrated and why victims sometimes respond in seemingly counterintuitive ways. And that is responding to the one of the dissenting opinions. And we do not, quote, shut our eyes to the enduring effect of rape culture on notions of consent and intent, as the respective dissents assert, footnote 8. On the contrary, consistent with our judicial role, our analysis is grounded on the bedrock principles of evidence and the defendant's constitutional right to the presumption of innocence and a fair trial. They say that Judge Singas would ignore these principles because, in her view, they fail to account for how rape myths distort jurors' perceptions of victims and corrupt the deliberative process. But justice for sexual assault victims, they say, is not incompatible with well-established rules of evidence designed to ensure that criminal convictions result only from the illegal conduct charged. Indeed, just as rape myths may impact the trier of fact's deliberative process, propensity evidence has a bias-inducing effect on jurors and tends to undermine the truth-seeking function of trials. Thus, when we limit Molyneux and other propensity evidence, we do so for policy reasons due to fear of the jury's, quote, human tendency to more readily believe in the guilt of an accused person when it is known or suspected that they have previously committed a similar crime. So they're going through the balance of why there are exceptions within propensity evidence, how those exceptions within propensity evidence work, and why the boundaries of propensity evidence are there. And the fear that a jury will be like, well, if they've done it before, obviously guilty, even if the evidence doesn't sustain it. So I'm not saying that is the case here. I am saying that is the concern, just so there's no misunderstanding of what I'm saying. So then they address more of the dissents. The dissenting opinion, again, is furious with this holding. Let's see. They go on to say, moreover, this was not a single victim prosecution where there arguably is a heightened risk that rape myths could impair the jury's fact-finding and credibility determinations. Indeed, three complainants testified to defendants' violent actions on different occasions years apart and how they behaved towards him long afterwards. There also were significant differences between complainants and the Molyneux witnesses. All three complainants had long-term relationships with defendant, where the other witnesses each interacted with defendant for brief periods. So, as they're going through this, they are making a stark contrast between the victims being able to testify to the charged victims. So, as I'm talking about victims, I am talking about count one, count two, victim two, etc. The other propensity witnesses or the bad acts witnesses, the things that happened to them are not charged in this case. So the court is not saying that the victims and the charged victims can't testify to what happened before, after the crimes that are charged that fall within the statute of limitations. They're not saying they can't testify to those things. What they're saying is the additional witnesses violated the defendant's right, and therefore the additional witnesses created the situation where we're in now, where the court finds that to be egregious error and that the case needs to be overturned there, and thereby going to new trial without the bad acts witnesses testifying. All right, continuing on. Let's see. I'm trying to get just to the end. In sum, we conclude that the testimony from the Molyneux witnesses, the uncharged witnesses, was unnecessary to establish defendant's intent and served only to establish defendant's propensity to commit the crimes charged. Neither the prosecution nor the trial court, quote, identified some issue other than mere criminal propensity to which the evidence is relevant, and therefore its admission during the prosecution's case in chief was error. So, here is the heart of what they are saying. The prosecution did not show that the witnesses whose acts were not charged were testifying to anything other than propensity, meaning you did it, so it's more likely you did it. There has to be something other than that, and they're saying that the prosecution and the court did not identify something other than that the prosecution's argument that this was to show intent was insufficient here. So intent is not going to fly for this court, which means if this is retried, which is within the prosecution's discretion, if this is retried, that those witnesses will not be allowed to testify. Generally, only the victims will be allowed to testify here. So the dissenting opinions are scathing. The beginning of the dissenting opinion, and a lot of this opinion is the holding opinion and the dissent going back and forth with one another. The dissenting opinion starts with fundamental misunderstandings of sexual violence perpetrated by men known to and with significant power over the women they victimize are on full display in the majority's opinion. By whitewashing the facts to conform to a he said, she said narrative, and by ignoring the evidence of defendant's manipulation and premeditation, which clouds issues of intent, and by failing to recognize that the jury was entitled to consider defendant's previous assaults, this court has continued a disturbing trend of overturning juries' guilty verdicts in cases involving sexual violence. The Molyneux rule created by this court has never been static. Instead, its use has evolved over time to meet the challenges of complex criminal prosecutions. Unfortunately, in the context of sexual assault, the evolution lapses today with a decision that has all but ended the use of Molyneux evidence in such cases. I fully join Judge Quintero's dissent, but writes separately to highlight how the majority's determination perpetuates outdated notions of sexual violence and allows predators to escape accountability. So when I say the dissent is scathing, the defense is scathing. Knit 1 Law 2 said, isn't there an exception relating to sex crimes? It depends on the jurisdiction. Not in every jurisdiction. In some jurisdictions, there are different carve-outs, but not in every jurisdiction. So in some jurisdictions, there are. So the dissents here are scathing, but the dissents do not change the holding. I'm going to go to the one quote I saw from the prosecution. Emily, did you make a note of exactly which article it was where the prosecution gave that quote? No, I didn't. I think it's from ABC. So pulling up ABC's story, because I'm pretty sure it is in here. Megan asked, did they object to the witnesses during trial? Oh, before, during, after, all. Yes, they did. Yes, they absolutely did. Harvey Weinstein's conviction overturned in New York. The New York Court of Appeals in a scathing, well, I mean, they did call it egregious. I think the dissents are more scathing than the majority opinion, but there is an ongoing fight here. The New York Court of Appeals in a scathing 4-3 opinion overturned Weinstein's conviction on sex crimes against 3 women, finding the judge erroneously admitted testimony of uncharged alleged prior sexual acts against persons other than the complainants, the victims, of the underlying crimes. The court said the testimony served no material propensity purpose. We went through that. Weinstein's spokesperson told ABC News, we are happily surprised, and we are studying the ruling. The Weinstein team, which was eagerly awaiting a ruling, was not expecting it to be in Weinstein's favor after a succession of rulings in different courts that all went against Weinstein. He also is convicted of sex offenses in LA and is sentenced to 16 years there. ABC says because he is already convicted in California, he will not be released and instead transferred to the custody of prison authorities in California. So he must be in New York. I'm trying to see if there is a statement at the very end. Prosecutors said the testimony of women other than those whose claims form the basis of the criminal charges spoke to Weinstein's state of mind to use forcible compulsion. The majority opinion, however, said that eviscerated the time-tested rule against propensity evidence. That is not the statement of prosecutors. There is a statement of prosecutors. Who did they give it to? I am trying to find it, and I am not seeing it. But there we go. Nope. I have not found it at all, though I know I read it, which was that prosecutors are going to speak with the victims and determine what their retrial will be or will not be. I'm going to answer questions in a minute, but I'm going to give kind of a summary of all of this because I think it's, well, at least I hope it is helpful. Let's see. Nope. I do not know where it is. Oh, here it is. To Variety. Wait. As I was trying to get it, it disappeared. To Variety, the district attorney said that they would be consulting with the victims and determining if they will retry the case. So as I was going to summarize real quick, here's where we're at. The Court of Appeals overturned Harvey Weinstein's convictions in New York based on the propensity evidence that was admitted at trial, the propensity evidence being non-victim testimony about prior bad acts in the case. The majority opinion found that the evidence did not have a proper purpose. There was no reason that evidence was admitted other than to show that because he had done something before, he had a propensity to do it again, which is in violation of not just the case law in New York, but a violation of the rules of evidence and the they say the long history of the case law in New York. Remember, different jurisdictions have different rules to deal with particularly propensity evidence in sexual assault cases. Jurisdictions vary widely on that. And if the legislature is like, hey, what is California doing with propensity evidence here? They can shift that. So in New York, the district attorney will have to choose whether or not they will retry this case, which means if they do, the victims will have to testify again at a retrial. His conviction in California is up on appeal. Remember, the conviction in California was a split conviction. Some of the counts in California were hung. Some of the counts in California were convicted on the retrial. So the first time he was not acquitted. The first time in California, it was hung on all counts. The second trial in California was convicted on some of the counts, hung on some of the counts. The counts that were hung in California, the DA's office in Los Angeles chose not to retry. So those 3 counts were just declared a mistrial and dismissed. So of the 4 counts that he was convicted of in California, he was sentenced to 16 years. I have not seen whether that sentence was changed or enhanced due to the prior convictions in New York. If that is the case, then we will likely see a motion in Los Angeles to resentence him because there is now no prior conviction in New York to base the sentencing in LA on. But he is sentenced to 16 years in LA. And so he will be sent from New York to LA to serve his time there. So that appeal in Los Angeles is still pending. And when that comes down, we will see what happens. One of the victims in the LA case who the jury hung on, which means they couldn't decide whether to convict or acquit on that count, was one of the propensity witnesses in New York. So what happens if they retry it in New York? Well, they don't bring in the propensity evidence, or they make a stronger case as to why the propensity evidence comes in. I would imagine that if they could make a stronger case for why it should come in, they would have done that, knowing that this is one of those things like jury instructions where bad acts evidence can get your case overturned. Too much bad acts, too far in the past, that overreaching is one of those things that can get cases overturned, and that's what we have seen here. Again, the rules in California for propensity in sexual assault prosecutions are different than they are in New York. The case law is different, and the rules of evidence are different, and there are different carve-outs in LA. So do I expect the same result in California? No, I don't. But that is still on appeal, but we are dealing with different rules of evidence and different carve-outs in the rules of evidence between the 2 different jurisdictions. So even though, and I understand the very strong feelings about Harvey Weinstein, if the legislature in New York changes the way that they carve these things out, they can do that. So they can absolutely choose to change that after this ruling. And then the courts are like, well, the people voted for the legislature changed the rules have changed. So then it's different. Can they retry it? Yes, they can. Can they choose not to retry it? Yes, they can. He is 72 years old. He is sentenced to 16 years in California. I don't know what the DA or the victims will choose to do or what they will want to do. I don't know if going through trial twice is worse than going through trial once. Going through trial once is difficult enough. I don't know if it's easier the second time for the victims. Anika said, no, he's 77. Sorry, 77. I don't know why I had 72 stuck in my head. So with all of that, I don't know if they will. Garrard said his age is irrelevant. Justice doesn't age out. I understand that, but it will factor into the prosecution's and the victims' discussion about whether they want to move forward. It will be part of the conversation. It will absolutely be part of the conversation. But what happens on appeal in California might also be part of the conversation because it is not easy. It is not easy to testify. It is not easy to go to trial. It is not an easy thing to do. So those will all be part of the case. I'm going to do some questions on this case before we move on to Baldwin because I know there's a lot of questions. Again, I know there are strong feelings. It's propensity evidence is easier to consider, like theoretically, when we are not dealing with a disliked, is that putting it mildly, defendant. It can be difficult, but the court system should not be win at all costs, and can't be win at all costs. But there are ways that the courts can accommodate for the things that we see the majority opinion and the dissenting opinion struggling with, and we have seen other states tackle those things. So whether that is a legislative tackle or whether New York is like, no, this is how we see propensity evidence, and this is how we are going to continue to treat propensity evidence, that's different. But if they retry it in New York, he's already been convicted in California. So now it's a different trial because there are, in fact, prior convictions. So it also shifts the entire landscape of the case. And maybe it shifts the landscape in the case to a place where there is not a retrial and there is, in fact, a settlement of some amount of jail time without a retrial, saying, okay, well, it was propensity before, but it's prior convictions now. So do you really want to retry it? Because he might not want to retry it. And there might be consideration for that as well, because now he does have prior convictions. And that's different than the case was last time. So it's part of the consideration. So can this be a long and winding road? Yes. Will we see what they will decide to do? Yes. Let's go to your questions on this case before we round this out and talk about Baldwin. Jennifer said, were the New York and California sentences concurrent? If not, does he get credit towards the 16 years in California for what he's serving in New York? I don't know if they were concurrent. Let me save that and I will look, but he is going to have to go back to California to serve where he is then. Joe Jersey said, so they can use the California as a prior conviction, even though at the time of the first trial, he didn't. Unless there is something prohibiting it, because when he stands trial, he now has prior convictions. It doesn't, your trial is never at the same point it was when you were originally tried. That's a retrial. So for better or for worse. Erica said, if they redo the trial, is the prosecution allowed to disclose he was convicted in the first one? No, they are not. Not in the first New York trial because it's overturned on appeal. But he was convicted in California. So the California conviction can come in to play in that way. Let's see. Lexi T said, I've had to testify in trial. I never want to do that again. The defense attorney was horrible. He was argumentative and an ass. They do that. He was trying hard to prove I was lying. They do that. I love the Emily dance. Prior on, propensity off. If they do a retrial, they might. So let's see. Jesse rah said, side note from a convo on stream the other day. Had therapy today, asked my therapist if jurors can discuss a case with their therapist. She said, yes, a good therapist won't influence. It was a great question that Nashay asked on Tuesday, and we had a really good conversation about. I love the feedback on that. So let's see. Question, if one of the New York victims were to write a book or sell a story to be part of a movie, etc., would he be able to claim defamation now that it's overturned? Oh, I think that's a much more the tea is ready. I see exactly where you're at. I think it's a much more nuanced conversation because I would need I hate being the lawyer answer of it depends, but it would really depend. Because this conviction doesn't say that things didn't happen. The conviction doesn't undo what happened that the victims have said has happened to them. In fact, a jury found that that happened to them. The conviction is not standing based on errors of the court allowing other testimony in. So it would be a difficult road. Um, and even if they said something like convicted uh, sex offender or convicted rapist or convicted this and that, he is convicted in California. So even there's kind of a parsing of it. So I would have to look literally narrowly at specific statements to answer that question better, if that helps. Sorry, it comes down to it depends. Um, Question, can he get a higher sentence if retried? I mean, yeah, because he has prior convictions, but if the sentence in I mean, I don't know if they would base it on the I don't know if they would use the prior convictions in California to raise his sentence in New York, if resentenced, if retried, if reconvicted. But is it theoretically possible? Yes, it's theoretically possible. Question, can new evidence come in that may have come to light? Yes. If there's new evidence that is proper evidence, yes, there's nothing stalling about that. Nanner says, is it just me or is YouTube being a pain in the spin ass today? There, especially on mobile, have been some quirks on the platform. There have been some quirks on the platform. So that. Let's see. Lynn asked, I got sidetracked with my dogs. Does the New York conviction being overturned affect the California conviction? If it was used at sentencing, we could see a motion for resentencing. Um, if the prior conviction was used and then overturned, I would have to actually research that a little bit. Because that alone shouldn't overturn it, depending on what evidence was allowed in the second trial in California. Um, but the California case is already up on appeal. Will this be noted? Yes. Will they argue it? Yes. So let's see. Ippy Fluffy, does the judge get a consequence of being overturned? No, it happens. Judges get overturned. They don't like it, but it happens. So let's see. What happens to the judge now if they admitted this evidence that the prosecution or the defense objected multiple times? Are there professional repercussions? No. Judges get it wrong. It is a part of the job. There's nothing. The appellate court disagreed with the judge, but there is nothing that was found. Their ruling was found to be an error, but there's not like a fundamental underlying thing that would have, a judge taken off the bench or something like that. Judges get overturned. It happens. I don't know in a career if there's a judge that has done trial work that has ever not had some sort of disagreement with the Court of Appeals. Also, judges can get overturned because the way they interpreted the law at the time, the Court of Appeals looks at it and goes, we don't interpret the law that way anymore. So, because we don't interpret the law that way anymore, we're overturning it. Even though the judge interpreted the law properly under the law as it stood, the Court of Appeals can interpret the law differently and then things can shift. So, no, there are not consequences for the judge. They don't like it, but there are not consequences other than potentially having to do a retrial. Let's see. David Kamikaze said, what if after the sentence in California is overturned, would it make sense to wait for the appeal to finish before messing this up more? David, I'm sorry, I don't understand the question. California is still up on appeal. He will start serving his sentence in California. I don't know if he was serving, he would have been serving some type of concurrent time, I would imagine, confined. And even though he was sentenced in California from the time he was sentenced, even though he was serving it in New York, I imagine he would be serving it concurrently in that way. But I can look and see before we end for the day. but they might ask to have him resentenced if his sentence was based on prior convictions. I don't know if it was. So let's see. Is he appealing the California conviction as well right now? Yes, the California conviction has been appealed and is on appeal. Let's see. Question, if resentenced in California, would it be the same judge who did the original sentence? Generally, yes. Pinky Mingo said, did he have the same lawyers in California and New York? I don't know. I don't think so, but I don't know. Time Sapling said, if the overturned trial was used as a prior conviction in the other trial and now it was overturned, can the other trial be used as a prior conviction in the new one? How can the other trial be used as a prior conviction in the new one? Because there is, in New York, he had not yet been convicted in California. But if they retry it, he has been convicted in California. So there is now a conviction in California on his record. So, I mean, I'm sure they'll argue about it, but I don't see what would block it from coming in. Lori asked, do we know if the same mistake happened in the California case? California has very different laws on propensity, or different statutes on propensity in sexual assault cases. So it's different. There are some specific carve-outs of how it can be used there. So the laws are different. So the circumstances are quite different. Celeste, can the victims from the conviction in California testify in the retrial, especially since the conviction can come in? Oh, that's really going to depend. Oftentimes the facts of the conviction will come in, but not always the underlying circumstances. It just depends if the underlying circumstances are allowed in. If the underlying circumstances are allowed in, then maybe. So is it possible? Yes. Is it a certain? No. No, it is not. So let's see. KJ asked, would it be a different judge if retried? Not necessarily. It doesn't have to be a different judge, but it depends. I don't know if that judge is still on the bench or not. Ace Rockhola, good to see you. We are doing well. I know I miss Coffee Talk too. It's been busy. Are we talking Baldwin today? Yes, we will get to Baldwin in a minute. We're just doing Q&A to round out the questions on the Weinstein stuff. Emma Max said, to clarify that question, would they wait to do any resentencing until after the appeal is over? Well, the appeal in New York is over. A retrial has been issued. So it's just going to depend. But the appeal is final. He can be retried, but the appeal is final. So that is the highest court in New York. So that is done. Let's see. Nikki said the headline is terrifying, conviction overturned, but the reality is much less daunting. He's still in prison and isn't going anywhere. He's not getting out of prison. Allison, I understand, and it is okay. You have to take care of yourself. First, I wanted to make sure that we had a conversation about what can and can't happen from there. It's frustrating. It is frustrating. I absolutely understand. Propensity is something that prosecutors and judges have to be incredibly mindful of, just like jury instructions. If you overreach, this is the concern. So when we look at criminal trials and go, could the prosecution do this? Should they do this? Is that going to create an issue on appeal? There are a few things that when they create an issue on appeal, they create an overturnable issue on appeal. Propensity is absolutely one of them. Tutberg said, would I take this case? I mean, as a defense attorney, no. But I also do not practice. Also, the prosecutors on the Weinstein case in LA are very, very competent and have a very long history in trying those types of cases. Those were not the cases that I tried. Those were very specifically not the cases that I tried. Boppet said, chat, we have questions. Emily, it depends. It's really, really hard in the forward casting of what can happen, because there are so many different avenues here. What we're really looking at is, will they choose to retry Weinstein in New York or not? Will there be a motion to resentence in LA if they used the priors to enhance his sentence, which I don't know if they did, and I can look real quick before you finish this. What will happen with the appeal in California now as it is ongoing? Those are really the three main questions. Everything else gets a bit far beyond those. And so then it depends on which kind of fork in the road we take. Can he take a plea deal with a retrial? Yes, he could. He absolutely could. He and the prosecution can settle it to not do a retrial. They absolutely can. Yes, they can. David Kamikaze said appeal in California to be heard before a retrial in New York. Maybe that's just going to come down to timing. The appellate court in California is not going to speed up, and the DAs in New York are not going to slow down to allow one to happen for the other, because they don't really, they don't interplay with each other that much, unless in New York they want to use the conviction in LA, and there's argument back and forth there. So Silently Me said, can this case be used as precedent for other cases like Kelly and Masterson that use prior bad acts without being convicted of them? Masterson was also tried in Los Angeles. Again, the law in California and New York is different. In Kelly, it was tried under federal law. I am not as well familiar with the differences between federal law and New York law, but this will be used, if it's used as precedent of anything, it's going to be New York cases, because the federal system, the California system, and the New York system are all different. So half of my it depends answers are, well, the jurisdiction matters and jurisdictions vary substantially. So Lynn says, do California have to apply New York time served in his California sentence? It's not the New York time that he served. It's from the time he was sentenced in California. He was serving time in custody. It doesn't matter where he's serving it. So that is time that he was serving after he was convicted, even if serving it at the same time. So at his age, would New York spend the money on a retrial? It might be a matter of principle for the DAs and for the victims. So it really just depends. Let's see. Medicated Moment said, palate cleanser, my psych told me it would take too long to test for ADHD and I should just put it out of my head and not worry about it. Medicated Moment, are you joking, or are you trying to shift my rage in a different direction? Because I really, what? That is not an acceptable answer, because you can't just like put it out of your head. No. And I am sorry. And also, no. So, please have fun pronouncing. Could use the laugh today. Thanks. Well, first of all, with the dyslexia, this is going to be a difficult one, but I'm going with harshmuck fuck something tadpole. That's what we're going with. We're gonna go with lyrics from an Offspring song. We're going with Mongoose. Forget about it. For all of the chat saying time to find another psych, yes. Your medical providers should hear you. Paige said, put it out of your head, but the problem is in my head. Yes. Chat, I love seeing how supportive all of you are. Nikki Crayon said, I see schmuck and tadpole. So that's where we are at. So let us continue on. I'm going to answer a few more questions and then we will move forward. Crafty Crafty said, UK subscriber, is it not double jeopardy? I've always thought if it was overturned, it couldn't be retried. Crafty Crafty, I'm so glad that you asked this question, because I know double jeopardy can be confusing, not just to our US audiences, but also to our international audiences. And also the movie with Ashley Judd is fantastic. So let's see. Double jeopardy. The twice put in jeopardy provision of the Constitution when there is an ordered new trial is different. This is considered a mistrial. So it is the way that there is I don't know Emily, how do you explain this simply, that a mistrial, double jeopardy, even though jeopardy did attach, you're not being twice put in jeopardy because you haven't been acquitted. You are still in jeopardy because the case has been mistried and is going to be tried again. So if there is a hung jury, you can be tried again. If you are acquitted, you cannot be tried again for the same crime. But this is not an acquittal. This is an overturn on appeal that can be retried. So it's not saying that you have been placed in jeopardy, you have been acquitted for the thing, and now you are placed in jeopardy again. The mistrial allows for a retrial, even when jeopardy is attached, and that includes overturning on appeal. So hopefully that makes sense. I don't think I explained it well. I don't know how to explain it much better. But it is, no, double jeopardy does not apply when it's overturned on appeal. Shawty asked, will this ruling have effects on singer R. Kelly's appeal? No. Completely different law that we are dealing with, because that is a federal case and that was a RICO case. RICO cases use a lot, RICO and conspiracy cases used a lot of uncharged acts, but those uncharged acts are showing the organization. They're not propensity acts, so they are treated differently. Hopefully that helps. Kate, thank you for the gifted memberships. Aaron Evans said, I know the state can appeal a not guilty, but can they push this kind of appeal ruling further up the appellate ladder? No, I do not see any grounds for the state to take the ruling of the appellate court up to, where would they take it? This is the top court in New York. So where else would it go? They're not going to take it to the U.S. Supreme Court because it's New York interpreting New York law. No, there is nowhere they can go. They need to retry or not retry. Chelsea said, do you think the New York prosecutor carries any blame here for not protecting the verdict, or is it solely on the judge? I did not go through all of the hearings in the New York case on Weinstein well enough to know if the prosecution, and I can only imagine they had a good faith belief that this was being used to show intent. And they believed, and there is a disagreement here, that showing the past acts was showing intent, and the court agreed with them. Ultimately, it is up to the judge to let things in or not let things in. Do prosecutors do well with restraint? Yes. But if the prosecutors are like, this shows intent and this is a pattern of intent, then that is important. Oh, give me 1 second, because my kiddo was calling during a school day, which never happens. So I'm going to put on music. That's not music. And I'm going to answer this real quick. Kiddo, give me 1 second. I'm on stream. I'm going to mute myself. Chat, I will be right back. Chat, did you stretch? Did you take a stretch break? Did you take a stretch break? I had missed my kiddo's text, which is why he was calling me. Did the stretch break music, did it help? Did we take a stretch? Weinstein is 72 years old. Emily, you're correct. Weinstein is somewhere between the ages of 70 and 109. How about that? So, hopefully that helps. All right. So hopefully the stretching helped. A good stretch break. No, do not be worried. Kiddo had questions about after school activities, and stuff that is going on and a form that needed to be filled out, blah, 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 blah. But I needed, he doesn't call during the day, so we're going to answer during the day to make sure everything is good. So let us get back to questions, and continue. So yay for the stretch music, but, no need to be worried. Can law enforcement put more time into holding enablers accountable? It doesn't seem to happen often. Again, it is hard for me to answer a broad question without a specific circumstance. I do much better with specific circumstances. Law enforcement, in my experience, on the things that come across their desk tend to be stretched incredibly thin. And even the things that come across their desk don't always get investigated. So I don't know what that looks like in practical effect. Honestly, I don't know what that would look like. Jennifer said, were the New York and California sentences concurrent? I meant to look this up. I don't. It's not that, I mean, it's not that they would be ordered concurrent, but he's serving time on the California case and the New York case, so they are in effect concurrent, because you can't really make one consecutive to the other because they are in different jurisdictions. So it would in effect be concurrent, if that makes sense. So Aaron said, follow up, if you don't think there's a court, does that mean an action brought in the state court can't? No, actions brought in the state court can go to SCOTUS. This one doesn't really have grounds to go there. There's not, A, the type of question that they would take up. B, the defendant is not going to continue appealing it. There's no mechanism for the state to do it. So no, it's not as broad as that. It is specific to this case. Marching step off today, measuring 261 kids. Oh, Nicole. That's a big band. That's awesome. But oh boy. Oh, that's a lot. That's a lot. Ours is next week. Good luck to you. That's a lot. So in the New York trial, can they now use California's prior convictions? If yes, what if California then gets appealed? California is getting appealed, but yes, they can use it. There will be motions about using it, and we will see. So, of course, there will be motions using it. Force cry in the out loud, but aren't these bad acts showing a pattern of behavior? Not in a permissible way. They do not show, according to the court, motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. So pattern of behavior is what they are trying to avoid in New York. In California, that's a little bit different because there are some carve-outs in the law in particularly sexual assault cases for patterns of behavior. If they're allowed the convictions in the LA case, would that be overturned as well? Not necessarily, but it could shift the sentencing. What does a person get? How does a person get a consult with you? Elisa, I don't do consultations. I just do content. My sister-in-law's maiden name is Grice. Yes, like rice with a G. Good. Basking in it said, love following all the fuckery with Emily. It's been a lot today. Kathy said ADHD is worse with TikTok. Everything in 15 seconds. TikTok is a lot. Felicity said, Emily, you're asking what I'm drinking. I'm drinking Sprite. Reminds me of my first visit to the US, and a bar wouldn't serve me a Sprite as I was under 21. What's up with that? I don't know. I don't know what's up with that. But generally, if you're under 21, bars don't allow you in the door if it's just a bar. But if it's a bar and restaurant, they should. Carrie said, will the miscategorization of employees bring the IRS to the yard? Not necessarily. Maybe the franchise tax board, but not necessarily. Question, did you get the doodle art? Stephanie, I have a pile of mail that I have not opened. So got it and have opened it are two different questions. So if it was sent, I probably got it. If I I have not opened mail in a bit. It's been a lot. Caroline said, I completely missed my year of subbing milestone. I appreciate you and what you do. Thank you. Rochelle said, thank you for being a voice of reason. I try to help us ground what we are looking at and experiencing in the why of the things, because I find it helps if we get to the why of the things, then we can figure out where things can change. Because if we don't understand the why, then we can't understand the what next. At least that is my perspective on it. Let's see. We need to do a mail opening stream, maybe. Nydia said, I've been a victim of the ADHD med shortage for over 2 months, but today I finally have my drugs back. Congratulations. The med shortage it's a lot. Like it's a lot. It's a lot to navigate. Like it's a lot to navigate. Mary said, when retried, can they introduce new evidence or are they limited to the original trial? If there is new proper evidence, wait, I pulled up the wrong one. If there is new proper evidence, they can. It's unlikely in this case because he's been in custody for quite a while. So it's unlikely there's something that has happened after. But if something is discovered, if it is proper evidence, then it is within the realm of possibility. It's unlikely in this case, but it's within the realm of possibility. So let's go to Baldwin. Are you guys ready to go to Baldwin? And then we can figure out the rest of it. Alon said, wait, there's an ADHD med shortage in the States. It's awful. Like it is a road to navigate. But yes, there is a ongoing and has been ongoing med shortage. I still don't understand like what caused all of that. It's like when you see a traffic accident, you see traffic slow down and there's like nothing happening. You're like, why are all of a sudden we stopping? There's like, I don't see a cause. That's how I feel about it. I don't see a cause. It's confusing. I'm confused. To be fair, I have not done much to understand the cause. I'm just like, meh, this is frustrating because ADHD. And I haven't tried to dive down a rabbit hole and try to figure it out. I just get frustrated. All right, we need to talk about Baldwin. And then if we have time, we will hopefully get to the very end of the Karen Reed hearing because I want to see them discuss the court layout. So that is my goal. So if we can go to Baldwin, then it is my hope to go to Reed. Mods, I'm sorry, I realize we're almost at like an hour and 45 minutes. Chat, how are you feeling? How are you doing? How I'm here. I'm sure some of you are feeling like this. Like, I get it. Propensity evidence is an issue. It is an issue we need to keep our eyes on. The New York courts are disagreeing on how to deal with it. And we will see where it goes from here. But for now, Weinstein will get a retrial if they choose to retry it. All right. Shall we get to lawyers fighting? Shall we do that? Shall we just do that? Okay. Chat, are we ready? Are we ready to go to New Mexico? Let us hop on EDB Air and leave New York. Goodbye, New York. We out. Baldwin's lawyers are so pissed. But they're pissed. They are pissed. Let's give a quick road so far. So, dealing with the shooting death of Helena Hutchins on the movie set of Rust. The armorer on that set was convicted in March and sentenced to the max of 18 months in state prison earlier this month. Alec Baldwin was indicted on the case. That indictment was then no prost or not prosecuted and dismissed. He was then re-indicted by grand jury on the case, and the defense made a motion to dismiss the grand jury. That motion relitigated every single beef that the defense has with the prosecution and has effectively buried the prosecution in hundreds of pages of litigation. They alleged that the prosecution gave improper jury instructions, that they elicited improper testimony from witnesses, that they failed to adequately provide Baldwin's exhibits or witnesses to the grand jury. The state fired back with, like, I don't know, 50 shades of shade, 50 pages of shade, 50 shades of shade, and then like a little bit of legal argument saying, nah, no, we didn't. The defense has fired back with, oh, yes, you did. So the state of the case is the defense saying, prosecution, you suck. The prosecution going, nuh-uh. And the defense going, yeah. We have now reached the yeah phase of the defense's reply. After this should go to a hearing. That hearing has not been set yet, unless it got set literally this morning. Let's see. Unless it got set this morning. The prosecution yesterday asked for the tape of the hearing and was like, I'm going to need to see if I said what the defense is saying I said. That's my interpretation. But we're going to see a hearing on this hopefully sometime in the near future, because this trial is set for July. I mean, we're at the end of April. They do not have a ton of time as court is considered. Like, court time and real time are not the same. Emily time is not actual time. It's a construct. So all of this is kind of a mess. But the prosecution did talk about Baldwin's ego. The defense threw a ton of shade at the prosecution. They fired back, and you're just going to have to watch me cover that entire motion because I can't summarize all of the snark. But the Baldwin's ego. What did they say about Baldwin's ego, chat? It was something about his impressive ego or what happened or what have you. It was a lot. Annie O said, is this the same prosecutors as Hannah's case? Yes, +1. So the impressive ego, because the defense keeps saying that the prosecution is just prosecuting this because they don't like Baldwin. And the prosecution's like, even though his impressive arrogance, that's right. Chat is bae. His impressive arrogance. They said basically his impressive arrogance aside, they are prosecuting the case because a crime has happened. The defense starts their legal filing. Look, here is their legal filing from April 22nd, 2024. They start their legal filing, and this is when I had to stop reading because I was like, oh shit. They start their legal filing with a quote, when the debate is lost, slander becomes the tool of the loser.
I have not seen a filing start with a quote since, was it Mike Lindell that was quoting Orwell? I think that was the last lawsuit that has had quotes. But when the debate is lost, slander becomes the tool of the loser. Anonymous. And probably Tom Sandoval and Alec Baldwin.
So this is where we're at. Lyndon said that's a bit much, but I laughed. It is a lot. It is a lot. It is a lot. Nikki's like, but where's the lie though? I mean, Allie says, and Benjamin Franklin, right? Introduction. Alec Baldwin's motion to dismiss raises serious legal issues, makes serious legal arguments. Alec Baldwin's team. We excoriated you for 100 pages, but be serious. Okay. Alec Baldwin's motion to dismiss raises serious legal issues and makes serious legal arguments that are supported by serious legal precedents. It's binding legal precedent. And carries serious legal consequences. not only for Alec Baldwin, but for all New Mexico citizens. The motion, therefore, deserved a serious response. Oh my God. Give me a headache. A serious response addressing Baldwin's arguments about the state's misconduct in the grand jury proceeding. Instead, the state responded with a 32-page Jerry made? What is this? What? This is a new one for me. What?
Jeremiad.
Jeremiad. How is that how that word is pronounced?
Jeremiad.
What? Okay, Jeremiad is a word of the day. I've literally never. Jeremiad, which according to the Oxford Dictionary means a long, mournful complaint or lamentation, a list of woes. Okay.
Jeremiad.
That's a new one for me. What I don't know. What's wrong with diatribe? I don't know. It's from the Old Testament. I am woeful. Who busted out their thesaurus for this legal pleading? But we've all learned something new, because I have never, ever heard Jeremiad as a word. JX says the Lamentations of Jeremiah. Well, there we go. So Bobby said somebody got it off their word of a day calendar. The list of lamentations. All right. Well, it is their burn book against Baldwin. Lisa says Jeremiad was a bullfrog. Chicago Doll immediately said was a good friend of mine. Chat again, untouched, unparalleled. I do not have a woeful list of complaints about you. Y'all are funny as fuck. Screaming Moth Vibe said they really said I'm going biblical on their ass. This is where we're at. I love learning. I love learning a new thing in a legal pleading. Also, how swift-witted the chat is. Okay, a 32-page burn book against Baldwin and his lawyers that does not cite a single
legal decision. It does not distinguish Baldwin's authorities and spends no more than 5 pages addressing the core legal issues raised by Baldwin's motion.
This fact bears repeating. The state does not cite a single legal decision in its entire brief. Michael Hayden in the chat said, for real, I'm a pastor, and I have never heard Jeremiad. Same. But, here we go. And then they say, literally, this fact bears repeating. The state does not cite a single legal decision in its entire brief. Literally. Period. Also, I seem to remember that when I went through the state's motion, I kept going, okay, but are we going to address the arguments? Like, just on and on and on, and on and on and on. Like, just But the defense invited it because the defense spent half their motion talking about prosecutorial misconduct. But they kind of had to, because that's the standard under which the court can consider whether or not they can yeet the indictment. So the state was responding to the shade, but then their legal arguments were literally at the very, very end. And I was like, where's the rest of the legal? Carrie said, it's as if the lawyers are writing legal docs in case the docs end up on EDB. I mean, at this point, I'm not mad about it. Are you not entertained? The fact that they used literally as a full-on fucking period, what is giving. Lyndon in the chat, you're a yes, Your Honor, bet. No cap. I can't. We've gone from a biblical list of bitching, a quote from Anonymous, to literally be serious. I mean, as far as legal reading goes, I'm not mad. A legal brief without any authority is not worth the paper it's written on. Your Honor, throw it away. Throw it away, Your Honor. Throw it away. Seriously. Literally. Yeet. Unfortunately, that is no surprise. For Special Prosecutor Carrie Morrissey, prosecuting Alec Baldwin has never been about the law. It is, in her words, about using the justice system to, quote unquote, humble a, quote unquote, arrogant celebrity that she dislikes. Well, according to legal filings, his arrogance is impressive. The state's now opposition is in quotes. The state's so-called opposition should be rejected and Baldwin's motion should be granted. The state claims in a brief devoid of legal authority that Baldwin's motion is just an attempt to ensure that the case is not heard on its merits and to discredit the prosecution so that a conviction becomes unlikely for reasons that have nothing to do with Mr. Baldwin's criminal culpability. I mean, that is kind of their job, though. The state has it backwards. The state's own misconduct, 2 years worth and counting, has discredited the prosecution. And the state's entire approach to the grand jury proceeding was designed to prevent the grand jury from hearing the case on its merits. The state elicited false testimony from its own experts to secure Baldwin's indictment, only to elicit the opposite testimony from the same witnesses a few weeks later in the trial of Hannah Gutierrez. Made numerous statements in Gutierrez's trial that contradict the premise of the state's prosecution to the Baldwin grand jury. We're going to get to a estoppel argument after this is all done. Violated the court's order on how to conduct a fair and impartial grand jury proceeding, including by refusing to contact witnesses that had information favorable to Baldwin's defense and withholding critical information from the grand jury, read inaccurate jury instructions to the grand jury, and diverted its own witness testimony and the grand jury away from the exculpatory evidence. That sounds like a woeful list of complaints. The list goes on and on. Emily, stop singing. On and on and on. And it goes on and on and on. I can feel it. Sorry, I'm done. And in the sludge of defamation, oh good God. And in the sludge of defamation that preeminates the state's brief, Special Prosecutor Morrissey now makes the stunning admission that her decision to rescind Baldwin's plea officer and pursue an indictment had nothing to do with the facts of the case. Rather, it was based on her mistaken assumption that Baldwin commissioned a documentary film about Rust. But did he though? But did he though? I have questions about that. Like, did he though? The state violated the US and New Mexico constitutions, violated the rules of ethics, and the most basic prosecutorial norms, violated the laws that apply to grand jury proceedings in New Mexico, violated the court's orders, misled grand jurors and the grand jury judge, and elicited false testimony from witnesses for these reasons. The indictment should be dismissed. Okay. So some of their arguments I still have questions about, including the jury instruction argument. Some of the arguments were cleared up for me in the state's motion where they cited what happened at the grand jury at the end, and that the judge gave like all the grand jury instructions, and that the state had the evidence printed out for the grand jurors if they wanted to access it right there, and that the grand jurors were instructed that they could get to the witnesses if they wanted to call them. Like all of those things they knew. The jury instructions continue to be the biggest question for me, but I imagine that the lawyers are having fun with the scathing responses here, because it's just gotten out of hand. This judge is going to take away all of your coffee. Like none of you are getting coffee at trial. Like you're going to piss off Judge Sumner. Either way. She's not going to be pleased, and she will take away your coffee, counsel. So just wait. Just wait. Argument. The state fails to address the majority of the arguments raised in Baldwin's motion. Your Honor, they didn't do their assignment. How can I do mine? It doesn't matter. They still take up all of their pages to do it. Either way. Baldwin moved to dismiss the indictment based on several grounds, including the state's intentional misleading of grand jurors, which prevented them from considering evidence they were legally required to consider. I don't know if that's exactly the state of things. And it's manipulation of the grand jury process in violation of the court's orders and New Mexico law. I'm worried about the jury instructions. That's like my biggest question. The relief Baldwin seeks is firmly grounded. Oh my God, if they say grounds anymore, I'm going to fall over. I'm scarred for life. All I can hear in my brain is grounds. Firmly grounded in New Mexico law and supported by binding judicial precedent, not binders full of precedent, requiring prosecuting attorneys to act in a fair and impartial manner at all times during grand jury proceedings. And they go and cite other laws standing for the same proposition of fairness. They say the state does not devote a single paragraph of its 32-page response to addressing any of the cases or principles cited above and throughout Baldwin's motion. It does not attempt to distinguish those cases by their facts or explain why it shouldn't be bound by the holdings of those cases. No, they simply said, yeah, we did. It's the Blue Jay again that grabbed my attention. He brought a friend who is not backing down. So the Blue Jay is fighting with the female Blue Jay, and the female Blue Jay is winning. So it's hilarious. We now have friends at the feeder. For your update on my bird feeders, they say that the state's motion does not attempt to distinguish those cases, nor does the state offer authorities to support its conduct. No, what the state said is that's not the way it happened. So instead, the state's response to Baldwin's motion consists almost entirely of irrelevant, false, unsupported, and highly prejudicial statements that serve no legitimate purpose. I mean, they were trying to explain. So the state begins its response with a purported recitation of factual and procedural history of the case as we know it. What follows is a 22-page missive attacking Baldwin. My brain first read that as missive attacking Baldwin and his attorneys, and not a single sentence of which is relevant to the legal issues raised on this motion, and much of which is false. These two sides have such a divergent opinion of what happened at this grand jury, it is hard to reconcile. Just give the court the entire grand jury transcript, and the judge is going to have to figure it out. Counting the number of attorneys representing Baldwin, their cities of origin, and the nature of the tasks they've been assigned, stating that Baldwin is, quote, a man who has absolutely no control of his emotions, describing a call between Baldwin and his family, which took place before he was interviewed at the sheriff's office and before he had been informed of Hutchins's death, inaccurately describing purported discrepancies between Baldwin's various accounts of the incident, purporting to describe Baldwin's history of attacks and deflection in unrelated matters dating back to 2007. These statements, and several others like them throughout the state's response, have nothing to do with the issues raised in Baldwin's motion and are clearly intended to prejudice potential jurors, tarnish Baldwin before Your Honor, and deflect from the fact that the state cannot cite a single legal authority to support its arguments. Your Honor, all the state can do is throw shade. They have no law. The state's failure to distinguish Baldwin's authorities or offer legal authority of its own constitutes a waiver. And then they cite case law for that proposition that the state has accepted the defense's position because they did not distinguish the authority. They were trying to distinguish the facts. At a minimum, the state has effectively conceded that it has no legitimate legal arguments to contest Baldwin's motion. As explained below, when the site does attempt to address a small handful of Baldwin's arguments, it does so by mischaracterizing Baldwin's position and then responding with a mix of irrelevant and inaccurate assertions that contain no legal support. Your Honor, it's a straw man, and they did it badly. Baldwin's motion to dismiss should be granted for these reasons alone. But we will continue. Chibi in the chat said 2007, basically as old as the Magna Carta. Yes. All the way back, 2007, 1887, 1707, same, Your Honor. Same. The state concedes that it violated the court's order and New Mexico law. Oh, I want to know how this happened. The state ensured that the grand jury would have no access to Baldwin's exculpatory witnesses or exculpatory evidence. They read in the letter, Baldwin's grand jury alert letter identified more than half a dozen witnesses who had information favorable to his defense, which was read to the grand jury, as well as numerous exculpatory documents. Baldwin also made a separate, which, by the way, just as a sidebar, is more than I've seen a defendant be entitled to in any jurisdiction. That doesn't negate the argument here. I'm just reminding everyone that the fact that the defendant has any right to participate in the grand jury proceedings at all is more than I've seen in any other jurisdiction. Could it happen in other jurisdictions that we have not ventured to yet? Yep. But in everything that I've covered, I have not seen anything where a defendant has the right to even have a letter read to the grand jury. The prosecution often is required to present exculpatory evidence, but the defense has no say in what that is, in if it's and how it's presented, in what witnesses are made available. This is quite favorable to the defendant and unusual from my experience in other jurisdictions. The norm there, but it is not something I have seen in any other jurisdiction. Diana in the chat said probably because he's a celebrity. No, it's the law in New Mexico. So it's the law in New Mexico. So it's unique. He has more ability to be involved in this process than I've seen in most grand juries. So let's see. Baldwin also made a separate submission to the grand jury judge that listed numerous questions that should be asked of witnesses to elicit exculpatory evidence. The state refused to present nearly any of the exculpatory documents, but they made them available, objected to presenting testimony from all but one of the witnesses, and refused to pose the questions that Baldwin listed. They're not obligated to pose the questions from anything that I've seen, and they read the letter, which is their obligation. This argument is not well taken by me. I think the jury instruction argument is much more interesting. Footnote 1. Although one of the witnesses on Baldwin's list, Detective Hancock, was questioned in front of the grand jury, the state deliberately failed to ask the questions that it knew would elicit exculpatory testimony from her. While, quote, the court declines to prescribe the exact manner of questioning by the state for any target alerted witness, it cautions the state that it may not, quote, intentionally question the witness in a manner intended to keep the witness from providing the grand jury with the information that the target wanted before the grand jury. So they're saying the state was cautioned that when they questioned the investigating officer, that they could not circumvent that information coming in. Following a hearing on this dispute, the grand jury court ordered the state to alert grand jurors to the existence of all of Baldwin's witnesses and their potential testimony. The court then ordered the state to make those witnesses readily available to avoid scheduling disruptions if the grand jury wishes to hear from them. But what it seems from the grand jury statement given by the prosecution in this case is that the grand jury said, no, we're good, and did not wish to hear from them if the grand jury wishes to hear from them. The court's order was issued in accordance with binding New Mexico law. That's not in controversy. As explained in Baldwin's motion, the state violated the court's order. The state did not make the witnesses readily available. How do you know that, though? Because the grand jury didn't ask to hear from them. They read out the list and phone numbers and information on the witnesses, and then the grand jury was like, we're good. The state also violated New Mexico law because it failed to present any of the exculpatory evidence from those witnesses or the documents that Baldwin identified. The state responded that it followed Judge Ellington's order to the letter because it presented Baldwin's alert letter verbally and in writing to every grand juror in the room. I am not convinced that they need to do more. I'm not convinced they need to do more. I might be wrong, but I'm not convinced that the state needed to do more than that. But the state does not deny that it refused to contact Baldwin's witnesses before the grand jury proceeding. I mean, they didn't say they didn't. Footnote 3. Baldwin identified his witnesses to the state on November 14th, and the grand jury's term did not begin until January 18th. Although the state was not officially ordered to make those witnesses available until a week before the grand jury term began, it could have reached out to them sooner. So, and it could have, but half those witnesses are also state's witnesses that they were, stop it. Oh, I can't say most. A number of those witnesses were witnesses who were preparing to testify in the Hannah Gutierrez-Reed trial. Like, it's not like they were witnesses that the state didn't know about or never had contact with, because they're witnesses that were state's witnesses for the trial. The state could have reached out to them sooner. They don't have to. And even if it chose not to, a week or more was more than enough time to do so. Indeed, when the state requested additional time to make travel plans and accommodations for Baldwin's witnesses in November 2023 before the grand jury proceedings were postponed, it told the court that 6 days would suffice. I'm not persuaded. Nor does it dispute that it failed to present the exculpatory evidence identified. They don't have to present it. They have to let the grand jury know it's available. Nothing says they have to present it. Instead, Morrissey essentially claims that she was free to ignore the court's order because, quote, the grand jury did not elect to hear from Mr. Baldwin's witnesses, and therefore no scheduling disruptions were encountered. At the same time, the state seeks to reassure the court that if the grand jury had elected to hear from Baldwin's witnesses, they would have been presented in person virtually after seeking and obtaining approval from the court or via video recorded statement they previously provided to law enforcement and pretrial interviews. Everything about that response is appalling. I'm lost as to which legal argument we're in now. What legal argument are we in? With the pearl clutching and the being aghast. I'm going to say this to my kids when they put off emptying the dishwasher. No, everything about that response is appalling. They were appalled. I'm lost. Your Honor, seriously. It's appalling. Literally. I'm not mad about it, though. I'm not mad about it. Grass folks said, wow, that's in the brief. I thought that was EDB commentary. No, that's in the brief. Literally. It's its own paragraph. We're going to find out why everything is appalling. First, it is incorrect that the availability of the witnesses did not matter. The state's claim that the grand jury, quote, had no interest in requesting the attendance of Baldwin's witnesses even after it was alerted to their existence is false. Really? So the state lied in their motions to the court. Can you cite me the transcript and not cite me back to your own motion? The state's claim that the grand jury had no interest in requesting the attendance of Baldwin's witnesses even after it was alerted to their existence is false. As Baldwin's motion demonstrates, the grand jury expressed significant interest in Baldwin's witnesses, especially Halls and Zachary, on numerous occasions. Yet, each time a grand juror began making inquiries about Halls or Zachary, or inquiries that only Halls or Zachary were qualified to answer, the state would firmly escort them in a different direction, redirect the inquiry to a different witness who was unqualified to answer, or rephrase the inquiry to match the evidence the state wanted the grand jury to hear and exclude the exculpatory evidence it didn't. They go on to cite case law saying by preventing petitioner from answering a direct, relevant question from a grand juror, the prosecuting attorney interfered with the grand jury's statutory duty to make an independent inquiry into the evidence supporting a determination of probable cause. Another case that says dismissing indictment where prosecutor failed to elicit exculpatory testimony that contradicted testimonies from prosecution's law enforcement witness. That will happen. The prosecution has to put on the exculpatory evidence. I just don't know that they didn't put on the exculpatory evidence. But it's hard. That portion is really hard to parse without the grand jury transcript, which the court will have and we do not. The state's approach violated both the court's order and the state's separate obligation to facilitate the grand jury's understanding of its role and the evidence and witnesses that were available to it. The state cannot hide the ball and watch as the grand jurors meander through the dark in hopes that they won't stumble upon a witness the state was ordered to make available, especially when the grand jury tapes make clear that the grand jurors were clueless as to the significance of Baldwin's alert letter. I don't know if that's true. They go on to say instead of taking responsibility for its role as, quote, an aid to the grand jury and its obligation to, quote unquote, facilitate the grand jury's inquiries into exculpatory evidence, the state seeks to divert blame to the grand jury judge for failing to keep the jurors informed by citing the court's obligation to notify grand jurors of their ability to subpoena witnesses. But like, that's also what the judge does though. There's like jury instructions that get read. And that should be in the jury instructions that get read. It goes on and cites the court's obligation to notify grand jurors of their ability to subpoena witnesses, noting that the grand jury, quote, has the power to order the attendance of witnesses and to subpoena witnesses. They go on to say, but that is irrelevant. It's not irrelevant. I don't think the state is obligated to notify them of that because it's in the opening jury instructions. I'm interested to see what the court has to say because that's not my understanding of it. There was no need for the grand jury to issue subpoenas to hear from Baldwin's witnesses because the state was ordered to secure their availability in advance. So their argument is they don't need to subpoena the witnesses, but they know they can ask for the witnesses. I think this is hair splitting. Maybe I'm being too harsh. I think it's hair splitting because subpoenaing witnesses means the grand jurors can ask that the witnesses be made available. Hey, can you go get me Dave Halls? We've got questions for him. They're made aware that they can do that. So it's splitting hairs that they have to subpoena them or not subpoena them because they're available. They were told what witnesses the defense had, and they could ask for those witnesses. They don't have to subpoena the witnesses. They could just ask, and then the witnesses have to be made available. So truly, I think that's a bit of hair splitting. It's like they have the power to subpoena. Subpoena means you can ask for it. They don't actually have to send a subpoena. I don't. Okay, moving on. Second, even if it were true that the grand jurors had no interest in this exculpatory evidence, in parentheses, it's not. That would not justify the state's violation of the court's orders or New Mexico law requiring that the exculpatory evidence be presented. That's true. This would also constitute an unjustified derogation of the grand jury's duty to order that exculpatory evidence be produced for its consideration. The grand jury has the option. They go on to cite the statute from 1978, that's a good year, that says it is the duty of the grand jury to weigh all the evidence submitted to it, and when it has reason to believe that other lawful, competent, and relevant evidence is available that would disprove or reduce the charge or that would make an indictment unjustified, then it shall order the evidence produced. Well, let's talk about that sentence, shall we? It's the duty of the grand jury to weigh all the evidence submitted to it. And when it has reason to believe that other evidence is available, then it shall. Well, what if they don't have reason to believe that other evidence helps? Because at the end of the day, if the grand jury is looking at this going like, well, I mean, he pulled the trigger, what other evidence do they want? Like, for an indictment, that may well be enough. So the grand jury might not have believed that there was other evidence that would disprove the charge. Therefore, they're not obligated to call for it. It's a if this, then that. They say, thus, according to Morrissey's own assessment of the situation, she either stood idly by while the grand jury violated its duty. Oh, that's a bit strong. That exculpatory information be produced, or she crafted the grand jury process such that she would refuse to present the exculpatory evidence and would ensure that the grand jury did not understand it had the independent right and obligation to order the evidence produced. Well, either way, the indictment was procured in violation of New Mexico law. I have more questions about the jury instruction. Finally, the state's half-hearted claim that Baldwin's witness, quote, would have been presented cannot be taken seriously. Seriously, Your Honor, the state concedes that it could have secured the physical presence of the witnesses since it references virtual testimony and pre-recorded statements. Footnote 4. On April 17th, Baldwin asked Morrissey to disclose all, quote, communications from October 1st through January 31st between any member of the prosecution team and any witness called to testify before the grand jury in connection with the case. Unsurprisingly, it says Morrissey responded, the state is not in possession of any responsive documents. They might have had phone calls, though, and not emails. They go on to say nothing in Judge Ellington's order permitted the state to present Baldwin's witnesses virtually, nor are unsworn video recorded statements and pretrial interviews a substitute for grand jury testimony or the additional testimony described in Baldwin's briefing that the court said should be elicited. They say should. Further, no video recorded statement or pretrial interviews even exist for several of Baldwin's witnesses, including one of the state's own investigators who was so appalled by the incompetence of the state's investigation that he said it was reprehensible and unprofessional to a degree I still have no words for and could not be remedied. I'm so curious why that witness wasn't called at Hannah's trial by the defense. So curious. In short, the state was required to present exculpatory evidence to the grand jury, but it failed to do so. And if the court finds that to be true, then that is a reason to yeet the grand jury. I just don't know if the court will find that to be true, but we don't have the whole transcript to evaluate. And what we have is two different sides with diametrically opposed versions of what happened at the grand jury, which is real hard to independently evaluate because both sides are like this. And it's like, well, we can't see the transcript. So it's like this side said this, that side that said that. We'll see what the court does. Like I don't, if it's as they say, then maybe. But the state's like, well, that's not what it is at all. So I don't know. They go on to say the court ordered the state to make Baldwin's witnesses readily available, and the state ignored the order. As a result, the grand jurors were denied the opportunity to consider substantial exculpatory evidence. They didn't ask for the witnesses, though. They say the state intentionally questioned the witnesses to elicit false testimony and avoid disclosure of exculpatory information, which would, if that's true, is a problem. Everything, when we're addressing this particular set of motions, everything is if true then, because it's if true then, because we don't know. In addition to the state's unlawful refusal to present exculpatory evidence to the grand jury, the special prosecutors questioned their own witnesses in a manner that violated the court's orders in New Mexico law. The state was required to present witnesses in a fair and impartial manner at all times. Among other requirements, the state was prohibited from intentionally questioning witnesses in a manner intended to keep the witness from providing the grand jury with information that the target wanted before the grand jury. And that's from case law and the court's order. They say the state intentionally violated that rule. The court's going to have to evaluate the transcript. They say, for example, the state's questioning of Detective Hancock steered clear of the exculpatory information she possessed. Hancock's investigation into the accident uncovered a flood of information favorable to Baldwin's defense, but Morrissey elicited virtually none of it. Well, virtually doesn't mean none, does it? She didn't elicit, for example, that Hancock learned it was the responsibility of Gutierrez, Reed, and Halls to ensure the gun was safe to handle. I don't know if that's exculpatory. Because the issue as to Baldwin is whether he pointed it at a person and pulled the trigger, not whether he loaded it. But that's where the jury instructions become an issue, which is why I think that's a stronger argument. And that Halls failed to properly inspect the gun before handing it to Baldwin, though other witnesses did talk about that. Based on the motions. Instead, they said Hancock told grand jurors that Gutierrez told her she opened up the cylinder of the revolver, showed Dave Halls what was inside, spun it, and gave it to him. Omitting Hall's highly exculpatory admission that when Hannah showed him the firearm before continuing rehearsal, he could only remember seeing 3 rounds, and that he should have checked all of them but didn't, and couldn't recall if she spun the drum. That's not exculpatory. No. Nor did Morrissey elicit the fact that Hancock was told by another witness that Baldwin had been very careful in handling the gun on set. Also not exculpatory. The state's questioning of Brian Carpenter, one of its paid quote-unquote expert. The shade. Experts don't like the shade being thrown at them. Expert witness was even more egregious. Not only did Carpenter pad his credentials to expand the scope of his purported expertise, but the state elicited false testimony that it was Baldwin's responsibility to ensure the safety of the firearm. Morrissey knew this was incorrect and yet elicited the statement from Carpenter anyway. I need the full statement. Indeed, just a few weeks after the grand jury proceeding at the trial of Hannah, Morrissey elicited the exact opposite testimony from Carpenter. At Hannah's trial, Carpenter testified it was the responsibility of Gutierrez and Halls, not the actor, to check and clear the gun, and that it's rare for actors to do that as long as you've done your safety check at least 2 other sources and moved through the process, then you've done all you should have done, citing back to YouTube to the trial. The state's improper jury instruction. There we go. Tell me more about that. The state's improper jury instructions, which mirrors Carpenter's untruthful testimony, magnified the harm of this false testimony. The state does not address these issues anywhere in its 32-page response. Of course, there isn't much one can say. Yikes. Of course, there isn't much one can say when the theory underpinning the case against Baldwin contradicts the theory underpinning the jury verdict in the state just obtained against Gutierrez Reed. Yeah, you start to have estoppel issues. You can't go into court and argue the opposite. I don't think it is the opposite, though. I think Hannah didn't do her job, and Baldwin's weapon safety was that he pointed the gun at a person and pulled the trigger. Not that he didn't check it. So yeah. I don't think those are inapposite. All right. Let's continue. The grand jury specifically warned the state that if its questioning runs afoul of the standards described above, it would entitle Baldwin to a post-indictment review of the grand jury proceedings to evaluate the fairness of the prosecutor's actions. Well, that's what we're doing right now. They say the indictment should also be dismissed on those grounds. The state attempts to disclaim responsibilities for its failures. The state's attempts to disclaim responsibility for its failures are unavailing. On a few occasions where the state does purport to address Baldwin's arguments, it does so by responding to misconstrued assertions that Baldwin never made. For example, the state claims that Baldwin's primary complaint about the state's grand jury is that it was too short. They did complain about that, though. Not even close. It was just right. Not even close. As Baldwin's motion made clear, the state's presentation violated the court's orders and failed to comply with New Mexico law in numerous ways that have nothing to do with the length of the proceeding. You did complain that it was too short and that there's no way they left adequate time and that it was rushed. Baldwin's point about the schedule for the grand jury proceeding is that Morrissey proceeded with the presentation even though she knew it would be impossible to present the significant exculpatory evidence that existed. I mean, I think that's an exaggeration. In the short time remaining in the grand jury's term, which means this is the grand jury at the end of its term, which means they're well aware of what their rules and obligations are because they've sat in other indictments over and over and over and over again. The state responds to this observation by claiming the grand jury presentation was one of the longest in New Mexico history. I'm just waiting for them to be like, it was the best. It was the longest. It was the biggest grand jury that has ever happened in the history of the world. Ay, ay, ay. It's impossible to know whether this is true. Do we even care at this point? But it doesn't, it's becoming like a parody of itself. But it doesn't matter because it's irrelevant. It's not irrelevant. You're bringing it up over and over again. Your Honor, they said it was long. They're exaggerating its length. The point is that the state charged headlong into the grand jury proceeding, knowing it would not be able to present the required exculpatory evidence. And the state said, no, this is the longest grand jury in the history of the world. And so we went into it knowing we had plenty of time because grand juries don't really take that long. They go on to say yet another fact demonstrating the state's bad faith. What's happening? The state's brag, the claim to have conducted one of the longest grand jury presentations in New Mexico history, actually shows how disturbing this prosecution has become. We've gotten to this level of hyperbole being unhelpful. The state's admission that it supposedly spent an unprecedented amount of time presenting Baldwin's fourth-degree felony case to a grand jury, even though it skipped over all the exculpatory evidence, shows only one thing. The state has invested an unprecedented level of commitment towards prosecuting Baldwin. Your Honor, they didn't have enough time to present the case, but they took so much time, it shows that they only give a shit about prosecuting Baldwin. It was both then too short and too long at the same time. MB said at this point, it's all an SNL sketch. I don't know why fourth degree felonies in quotations. It actually is a fourth degree felony. I don't know why we're quoting that, but okay. If capital murder cases are, quote, routinely presented to a grand jury in under 3 hours, as the state claims, yet it took the state a day and a half to present its case against Baldwin, the only plausible inference that can be drawn is that the state's agenda against Baldwin is wildly out of control. Okay, this level of hyperbole is unhelpful. Footnote 6. According to public records, a substantial percentage of the first judicial district attorney's total spending in 2023 went towards prosecutors related to the Rust indictment. No incident. A percentage that is likely to increase in 2024 as special prosecutors continue to throw taxpayer dollars at Baldwin. Wait, no, at Baldwin's prosecution. And then it lists a whole bunch of articles about that. It then goes on to say, meanwhile, the state faces a budgetary crisis that is severely impacting the criminal justice system and the rights of New Mexico citizens. Ladies and gentlemen of New Mexico, Alec Baldwin would like you to know that your money is being wasted prosecuting him. Moving on. Lily said, wait, is this an SNL bit? We're doing a bit at this point. I feel like we might be doing a bit. I feel like we're there. Like, I don't know. I'm not in on it, but I feel like everyone's doing a bit at this point because we just argued that the indictment was too short to be, or the grand jury proceeding was too short to adequately present the evidence. But then they spent so much time on it that it just shows that they don't have a case, I guess. Similarly, they go on to say the state claims that Baldwin demonstrated his ignorance of the rules of evidence as they pertain to grand jury proceedings by criticizing the state for presenting its investigator, Connor Rice, to testify as to hearsay related to the investigation of the incident. But Baldwin never argued that hearsay was inadmissible in a grand jury proceeding. The word hearsay appears nowhere in Baldwin's opening brief. What Baldwin argued is that it was inappropriate to present Rice, a paid private investigator, to testify about the firsthand knowledge of witnesses the state was obligated to but did not make available. We're splitting hairs again. And that this was especially problematic. Every motion I've read. Every one lately. And that this was especially problematic because Rice both failed to present the exculpatory evidence that should have been elicited from those witnesses and demonstrated extremely limited knowledge of the relevant facts. The state's misdirection appears in other places as well. For example, Baldwin's motion observed that the state's improper attempt to shorten time to submit a grand jury letter further evidence the state's bad faith and intent to manipulate the grand jury process. In response, the state simply repeats and incorporates the arguments in its original motion. Not only did the grand jury judge reject those arguments at the time, but it's now clear that even those arguments were made in bad faith. Specifically, the state responded to the court that it needed to shorten Baldwin's time to submit an alert letter so that it could have additional time to make travel plans and accommodations for any witnesses it was ordered to make available. Yet, when the state was ultimately given a full week to make travel plans and accommodations, it didn't bother to contact any of the witnesses, they say. They say the state dodged all of Baldwin's legal authorities and nearly all of his substantive arguments. And on the rare occasion when the state did engage on the issue, it set up and struck down straw man arguments that bore little or no resemblance to Baldwin's actual position. The court should therefore reject each of the state's responses. This is what I wanted to read. How many pages in are we? Too many. The state issued an improper jury instruction as demonstrated in Baldwin's motion. Why are they leaving this for last? I find it the most persuasive. As demonstrated in maybe they don't. As demonstrated in Baldwin's motion, the importance of the state's jury instruction was that probable cause existed to indict Baldwin for involuntary manslaughter if he discharged a firearm during the production of a movie without first verifying the firearm contained no live ammunition and while the firearm was pointed in the direction of another. And if he should have known the danger involved from those actions. I think the problem is that the state never should be pinning their case on without first verifying the firearm contained no live ammunition. I don't think he's obligated to do that. I think that is an issue. I think it should be anyway. while the firearm was pointed in the direction of another and should have known the danger involved in those actions, pointing a firearm at another. They say the instruction violates New Mexico law, and if that's true, it is a problem. The state effectively instructed the grand jury that Baldwin had a duty to check the firearm for live ammunition and to refrain from pointing it at anyone. I do think he has a duty to refrain from pointing it at anyone. But those are precisely the questions that the grand jury was supposed to decide for itself based on the evidence, not based on immutable instructions of law. Once grand jurors were told that Baldwin had such a duty and didn't obey it, what's left for them to decide? I find that to be their most persuasive argument. If the job of the grand jury is to decide whether Baldwin had a duty here that he violated, then that's a problem. The state argues that it did not deviate from the UG Uniform Jury Instructions, and it simply filled in the language that was required to be filled in and did so in accordance with the instructions and facts presented. I don't think if their facts are that Baldwin had to verify that the firearm contained no live ammo, this trial is not going to go well for the state. Because I think even their own experts contradicted that. I lost my place. That's not helpful. To justify the way the state filled in the language, the state argues the reason Baldwin's behavior was in violation of the law is because he pointed a gun at a person, cocked it, and pulled the trigger, having no personal knowledge what type of ammunition was in the gun. I don't think he was obligated to know what type of ammunition was in the gun based on the evidence we saw in the last trial. I do think he was obligated not to point it at a person and pull the trigger. So I think there's a split there. It further argues that Baldwin had a duty to confirm that only inert ammunition had been placed in the gun before pointing it at a person. I don't think he has such a duty. Cocking it and pulling the trigger as a gun handler in the state of New Mexico, subject to New Mexico laws, and his failure to do so resulted in a negligent homicide as long as the other elements of the crime are satisfied. It says those are fictitious statements of law that the prosecutors fabricated out of whole cloth without citing a single legal authority. Well, did ChatGPT write them? I have questions. Instead of citing legal support for its legal position, the state claims that the legal instruction was appropriate because of the facts presented to the grand jury. To begin with, this is a non sequitur. The state cannot create a legal standard using facts. The legal standard is what it is, and the facts then tell us how the legal standard applies in the circumstances. I don't disagree with that. Moreover, it says the state further prejudiced the grand jury with this approach because the grand jury hadn't been presented with any facts when the state first read the instruction, which primed the grand jury to view the evidence through the state's unsupported legal theory. They say the state's effort to avoid the law by wrapping itself in the facts presented to a grand jury also collapses for two additional reasons. The state not only failed to present numerous exculpatory facts, we've already been over that, but the state's grand jury instruction contradicts its own statements and experts at Gutierrez's trial. That's going to be an issue at this trial if we get past this. And then they start citing what happened in Gutierrez's trial. And these are statements from Gutierrez's trial, but these aren't statements that were presented to the grand jury. I don't know what the state is going to make of those. Excuse me. They say each of these statements made by Carrie Morrissey to this court as an officer of the court contradicts the premise of the state's instruction to the Baldwin grand jury on the theory of its case before the grand jury. It also highlights the extensive exculpatory evidence the state knew about but refused to present. So they're saying, the prosecution saying, that Hannah Gutierrez is the decision maker with regard to gun safety. Gutierrez gets to do what she wants when it comes to gun safety. That Halls is just there to be a second pair of eyes. That you can tell dummies apart. They're saying all of that contradicts the state's theory, and that Mr. Carpenter did the same. I'm not going to reread through the entire thing. It was in their last motion, and we've already done it. They say Carpenter acknowledged that the actor has no obligation to even watch the gun being cleared. The state's reply does not dispute any of these statements or testimony or justify its improper presentation of contradictory facts to the grand jury. That I don't think is an issue that overturns the grand jury. I think that becomes a huge issue for Carpenter at trial. But the jury instruction argument, again, is interesting. They go on to say the state admits its bad faith motives for pursuing an indictment. Did they, though? Baldwin's motion sets forth several examples of the state's bad faith conduct before and during the grand jury proceedings, including Morrissey's statements to the media that the purpose of the state's prosecution is to quote unquote humble Baldwin because she finds him arrogant and wants to give him a teachable moment. She's stealing Amy Van Dyken's line. I am outraged. That response is appalling. I am appalled. Sarcasm. Sarcasm. But that was never published. That is what a reporter told Baldwin's lawyers that Morrissey said to them. It's a literal game of telephone. So make of that what you will. Baldwin also details Morrissey's sanctionable conduct in connection with her violation of the judge's confidentiality order. In response to Baldwin's motion, the state does not deny making the statements or disclaim improper motives they reflect. Instead, it corroborates them. I didn't read it that way, but okay. The state's improper motives for prosecuting Baldwin are reflected in Special Prosecutor Morrissey's own words explaining her reasons for rescinding Baldwin's plea order. On October 5th, the state offered Baldwin a, quote, very favorable plea agreement with the intention of ensuring that similarly situated defendants did not receive disparate treatment. According to the state, it only seemed fair to offer Baldwin the same deal that was offered 10 months earlier to Dave Halls, who told the state he was, quote, the last line of defense to protect against this accident, and who testified at the Gutierrez retrial that he accepted the plea deal because he was negligent in checking the gun properly before he handed it to Baldwin. The state gave Baldwin until October 22nd. Yet, the state withdrew the plea offer long before the deadline, shortly after Baldwin's attorneys contacted Morrissey to discuss the offer. Morrissey says she withdrew the offer because she believes Baldwin had, quote, commissioned his own documentary about Hutchins' death and sought to interview witnesses for the purported film. Trial witnesses. Trial witnesses. Linden said so they wouldn't have taken the agreement, but they're angry Carrie took it back. That seems to be what it is. Good to see you, Octo. As an initial matter, the information that ultimately prompted Morrissey to rescind the plea deal is inaccurate. Wait, why is this footnote 100 miles long? Footnote 11 is half the page. Okay. On December 12th, Halls sat for a deposition which Morrissey attended in connection with the state's case against Gutierrez. Halls asked whether he believes, quote, any one person bears, or Halls was asked, whether he believes any one person bears responsibility for what happened to Miss Hutchins, or was this an accident that was caused by multiple people and multiple events? In response, Halls listed, quote, in order of importance, what he believed to be the causes of Hutchins' death. Hall's perception of the situation is not like binding on anybody. In response, Halls listed in order of importance what he believed to be the causes of Hutchins' death. Certainly, the number one important factor in all of this is that a live round of ammunition ended up on the film set. Agreed. 2, that the gun was not checked properly by the armorer and myself. 3, the camera crew resigning left the camera crew shorthanded, which forced both Helena and Joel into the church to look at this teeny onboard monitor, to look at the shot, and to light the shot. He further testified that as Hutchins was looking at the monitor, she was telling Baldwin where to point the gun and that he didn't know if Baldwin knew he was pointing it directly at her. And that looking back, if perhaps he had seen all of those rounds, he would have taken appropriate action. Morrissey, who watched Halls give this testimony just 5 weeks before the grand jury, refused to make Halls available for the grand jury. I think most of that might be accurate, but I don't think refusing to make him available is accurate. And she continued to deny them access to Halls even after a grand jury specifically asked, quote, "So the bottom line is the responsibility for making sure these guns, these bullets are not live, are up to what? Dave Halls and Hannah?" Chat, tell me if you think that question means they want testimony from Dave Halls. If a grand juror specifically says, "So the bottom line is the responsibility of making sure these guns, these bullets are not live, is up to what? Dave Halls and Hannah?" At that point, Morrissey had an absolute duty to allow the grand jury to hear from Halls directly. Instead, she stated, "We are going to have another witness address those issues for you." The witness she was referring to was Brian Carpenter, whose testimony directly contradicted the answers Halls would have given and Carpenter's own sworn testimony in Reed's trial. Halls was on the list, and the grand jury could have asked if they weren't satisfied. I think the issue here is they're saying Carpenter's testimony contradicts Halls' answer and contradicts his own testimony at the trial. So as far as Baldwin is aware, there are 2 documentaries currently being made about the Rust tragedy. I'm just going to say I have no knowledge of any of that. The first is a documentary by Rachel Mason, which, according to news reports, has the full support of the Rust production and Hutchins's husband, who was involved as an executive producer. Footnote 12. Rust production named cinematographer to succeed Helena Hutchins announces documentary about the film's completion. The second is a documentary by filmmaker Rory Kennedy. Baldwin has no ownership or financial stake in either documentary. He didn't hire Kennedy or commission her documentary. He has no title or credit in either documentary. He's not a producer. He has no control of any kind over either documentary. In both documentaries, he is only a subject. So he knew about them, along with other members of the cast and crew. Baldwin never commissioned a documentary about Russ or Hutchins's death. Footnote 13. To the extent Morrissey has been informed otherwise, she may have, quote, received her information from an inaccurate article in the Daily Mail, a British tabloid that reported incorrectly that Baldwin, quote, hired Kennedy to make a documentary film about him. See article, quote, Alec Baldwin hires Oscar-nominated Rory Kennedy, RFK's youngest child and sister of longshot presidential contender Bobby Jr., to film his every move for documentary about his ill-fated movie Rust with all-female crew. That's a really long title. Okay. So they think Morrissey is relying on the Daily Mail when making prosecutorial decisions. I really hope that that's not true. Morrissey's stated reason for rescinding Baldwin's plea offer is a completely inappropriate basis for prosecutorial action and alone demonstrates her bad faith. It's odd that she put it in her motion, though. Honestly, it might have annoyed her. It's odd that it's in the motion and that it wasn't confirmed. Thus, in addition to the fact that her basis for withdrawing the plea offer long before the written deadline is not even true. They've never said they were going to take it, though. Like, all of this is a red herring. That's in addition to the fact that her basis for withholding or withdrawing the plea offer long before the written deadline is not even true. Morrissey makes numerous other false statements in her brief about the events resulting in the dismissal of the case. Interesting. For example, she falsely states that Baldwin's counsel said Harrison Ford and Helen Mirren would be testifying at trial. Wait, that's not true? What is happening? Morrissey's assertions about what Baldwin's counsel told NBC around the time of the plea offer are also false. I want Han to testify. Bring me Harrison Ford. Can you imagine? Why would Harrison Ford even... Why the fuck? What? Harrison, when Han shot first, were you pointing it directly or not? What is the actor's responsibility? I want to know. I'm teasing. Ah. As one of several examples, Baldwin first learned about the state's intended plea offer. I don't know why I said offer, as well as the state's decision to prosecute Baldwin. Instead of reinstating that offer after the parties discussed it, not from the state, but from NBC, when it sought comment about those developments. It would be easy to go one by one through the rest of the state's inaccurate, unprofessional, and ad hominems attacks. And that's exactly what the state wants Baldwin's to do, because the state's largely irrelevant brief is designed to defame Baldwin and his counsel, and therefore divert attention from the state's proven misconduct and inability to cite a single legal authority to support its position. Period. Morrissey's stated reason for pursuing an indictment are completely divorced from the public interest and reflect a stunning abuse of prosecutorial power. Baldwin's motion to dismiss demonstrated a litany of defects in the grand jury process, defects that were more severe and more numerous. The most severe, the most numerous, the many, 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 than we were able to locate in any single reported judicial decision in New Mexico. Your Honor, this might be the longest grand jury in the history of New Mexico. It is also the most problematic, literally, period, on God. Dead ass. The litigation leading up to this trial is going to be exhausting. These attorneys are so at odds with each other. I don't even feel like I know what happened at this grand jury, because everyone's take on what went down is so different. Rachel Riker in the chat said, "Oh my God, my high schooler just got home and heard an EDB say Harrison Ford." It goes, "What? How? Harrison Ford is dead." No, Harrison Ford is definitely not dead. Emma said, "I would pay so much good money to hear a lawyer use dead ass in court." It's going to happen. Give it 5 years. It's going to just give it 5 years. We're at serious, literally, and problematic. Okay. Where were we? We were at dead ass. That's not actually in this motion. Sorry. This is the most problematic grand jury in the history of the world. Deny the grand jury exculpatory evidence. What is that sentence? I'm so confused. Okay. Baldwin's motion to dismiss demonstrated a litany of defects in the grand jury process, defects that were more severe and more numerous than we were able to locate in any single reported judicial decision in New Mexico. Deny the grand jury exculpatory evidence? Baldwin cites a decision justifying dismissal for that defect alone. Refuse to facilitate the grand jury's access to exculpatory evidence, divert the grand jury from hearing testimony relevant to its explicit inquiries, and refuse to present exculpatory evidence that contradicted testimony from the prosecution's law enforcement witnesses. Baldwin cites cases that justify dismissal for each of these deficiencies. Read the grand jury an inaccurate legal instruction. Baldwin cites a separate case justifying dismissal for that too. Conduct the grand jury proceeding in a manner that renders them fundamentally unfair. Baldwin has listed a mountain of misconduct by the state and authorities that justify dismissal. In addition to these and other unrebutted judicial decisions, Baldwin cites several statutory provisions that justify dismissals. Your Honor, we have more law than anyone has ever had. We have stacks and mountains of case law and stacks of errors. Your Honor, all. Literally. I think without the entire transcript of the grand jury, which we're never going to get, it's difficult to parse whose version of the facts are the facts, because they all see it very differently. I'm curious about the jury instruction. The jury instruction is a problem, I think. I'm curious to see what the judge does there. I think the jury instruction seems to be at issue literally, legitimately. The jury instruction is a big question for me. The rest of it, I think, is splitting hairs. They clearly don't see it that way. Of course they don't. But it seems that the prosecution needs to make witnesses available, and telling them that the witnesses are available is sufficient. That seems to be the law. So the conclusion, for the above reasons, dismiss. Okay. And then they attach an email, a very long email asking for discovery and other email communications between the state. But we are almost 3 hours in. Oh, and this is the part of Halls's deposition that they cited. We are almost 3 hours in, but I do want to see the end of the Reed hearing. Chad, are you down? Can we do it? I think we can do it. What does pro hoc vice mean? Pro hoc vice means essentially for this matter only. It is where out-of-state attorneys in good standing can appear in front of the court in whatever jurisdiction. So lawyer admitted to practice law in New York can then appear in New Mexico, pro hoc vice, so that they can argue the case. All right. You guys are like, do it. Okay. Everybody's ready to roll. Let's ride. I agree. And then we're back in court on Monday. So let's ride. All right. Let me try to summarize this. We're going to try to get to the end of that hearing. We're not going to do the whole thing. It is way too long, but I want to hear the argument about the jury box. Let's see. Karen Reed hearing. And then does anybody else have this? No. Yes. All right, we'll do that in just a second. Let's see if I can summarize what happened in the Baldwin case. I think I did. Nuh-uh, yaha, nuh-uh, yaha. Baldwin's attorneys, in their reply in support of their motion to dismiss the indictment, have quadrupled down on arguing that the state has engaged in misconduct, that the state did not cite any legal authority or distinguish any legal authority in their motion, and that the motion was just further evidence that the prosecutors are pursuing Baldwin for improper purpose. Their motion started with a quote from Anonymous saying, "When the debate is lost, slander becomes the tool of the loser." In a lengthy motion, they have again pointed out that they believe the state did not properly present exculpatory evidence, that the state gave the wrong jury instruction or a improper jury instruction to the grand jury and failed its basic duties, and that the entire thing is improper and the prosecution is going after Baldwin to humble him and to teach him a lesson. There is no love lost between these attorneys, and the litigation is going to continue to be incredibly feisty, but it is definitely full of snark. So there is that. I don't know if this indictment will get dismissed. If it does, we're going to be starting all over again from scratch. But they also clarified that Baldwin has not commissioned a documentary and that there are, in fact, 2 documentaries underway regarding Rust, the return to filming Rust, and everything that has happened in this case. But Baldwin is not involved with those or financially attached to those, and the prosecution revoking his plea deal for that reason is again improper and shows the lengths that the prosecution will go to get after Baldwin. All right, let's go to Massachusetts, shall we? I'm going to try to zoom to the end of this hearing I'm hoping to get to the argument on the jury box. That is what I am looking for. Lots happened today in the Karen Reed case. I summarized it on the podcast last week. Opening statements start on Monday. The things that happened in court that I am not going to go through in this hearing, and those are available on all of the channels that have the hearing, were the motions where everybody agreed, things that had been previously ruled on, what is going to happen in opening statements. The court gave each side 45 minutes for opening statements. So we will get to testimony on Monday because they gave everybody 45 minutes for opening statements. And then they were talking about some of the prior bad acts or character evidence regarding a incident in Aruba between the victim and the defendant. They talked about the pending IA investigation into the lead detective in this case, Trooper Proctor, and what is allowed to come out about that investigation. Does it go to bias? How it will come in? Most of what I saw the court do this morning was, yes, I hear you. Let's get to this down the road when it comes up, and not really getting into the details of the things that haven't been decided yet. All right. Let's see. Actually, let me see if I can make this full screen real quick because it just works better. And let's see. Full screen. There we go. Let's see where we're at in this hearing to try to get up to time as they're talking about the jury box. The argument was that kind of the back 9 jurors were looking at the back of the witness's head. I showed that picture on Tuesday. I was like, this is a case about credibility. How can you even judge the credibility of someone or pay attention for 8 weeks if you can't see them? It's just not helpful.
And there were, updates that were provided to Kevin Albert by a trooper under.
Okay, this is still arguing the IA. Let me zoom just a little bit to see if we can get to that motion. I'm going to also gain this up just a little bit. Oh, we'll be back in court on Monday, folks. Are you ready?
Phone call from Chief Berkowitz to DA Morrissey, where, as I'm understanding it, there were only 2 people on that call, and the Commonwealth is seeking to take.
This is in the middle of argument over whether or not the elected district attorney can be called as a witness in this case. That's where they've gotten to now.
Tell me, are there any agreements of counsel? Is there?
Here, I'm going to back up to see what the court is saying, because hopefully the court is closing out that issue and then moving on to the next one. So let's see.
So, Jim, I'll write something short on that. I've written the part about Mr. Nelson that I'll give you afterwards.
And we don't have closed captioning on this feed.
All right. So when we had our motion in limine hearing, I think we went much of the day that Friday. I don't remember if it was last Friday or the Friday before. I ended that with saying twice, is there anything else we need to discuss regarding housekeeping or logistics? And I was told no by both parties.
Uh-oh.
And then I get a motion the following April 9th.
Also, for all of you that heard my story about my colleague whose desk got barricaded by books, the books behind the judge are those books. I mean, they're the California version of those books, but are exactly those books for those of you that need a visual.
19th, the end of last week.
This is about the jury box.
About wanting to use not just having an a technology audio visual assistant at counsel table, but to use it's much more extensive than what I expected. The Commonwealth filed their motion and it was allowed previously because it happens in every single case in these courtrooms, and the Commonwealth shares their equipment. Please tell me exactly what it is you want to do. And I'm mindful also of the fact that during impanelment, while we were actively on trial in this case, in a critical part of the case, your audiovisual person, who I had never seen, was sitting where you are, Mr. Yannetti, talking to your client. So it sounds like he's taking liberties in this courtroom, and I need to know exactly what you need him for and what it is you intend to do. Keeping in mind also that we're going to be now in a much smaller courtroom. So
I guess they are moving.
Tell me, are there any agreements of counsel? Is there any?
Did we miss it? We might have missed it.
About this, and I asked for information previously, so I could have thought about it and seen a demonstration or heard something. What is it you're asking me to allow?
Thank you, Your Honor. It's very modest. We did mention that we were going to ask for this
But you didn't
accommodation.
do it in writing, and you didn't give me specifics.
Your Honor, we asked you, and you then said, put it in writing. Then we put it in writing. And we
But
did
the first
exactly-
time it was brought up was after I had
Oh,
asked
God.
about logistics. Go ahead. Tell me exactly what it is you want to do.
Okay. So it's a very...
The judge, you didn't tell me. Your Honor, we told you. The judge, we didn't put it in writing. The defense, so we put it in writing. The judge, but why did you put it in writing now? The defense, because you said to put it in writing. Oh dear.
very modest request.
We're just
under ordinary circumstances, and we've utilized his services before. He would sit at counsel table.
This is their
He
AV
would
person.
Run sort of the AV to make it seamless and smooth for everybody, for the jurors, for the court.
Your Honor, you want the parties to have an AV team. Otherwise it's going to be a mess.
For the court reporter, for
This is not
opposing
loud enough.
counsel. He can put monitor.
That was oh boy. They're doing this now so that this doesn't have to happen once the jury is there and seated and sworn in.
Monitors at the request of the court, put monitors on the bench.
I gained the volume up and it did
Court
fuck all. Hold on. We're as gained as we can get. It did nothing.
reporter a monitor in front of the Commonwealth and a monitor here, all small, relatively inobtrusive monitors. He also can run the system of AV, in other words, putting up evidence. I'm looking at evidence binders that Mr. Lally and I are going to be visiting about through the day today and tomorrow. There's hundreds and hundreds and hundreds of photographs in here, multimedia, that's going to need to be played and shown throughout the course of the trial. Instead of walking back and forth and doing it sort of...
No, and that's what we do every day in this courtroom.
Right, and that's what he does every day in courtrooms as well. I mean, we're asking for is an accommodation exactly like the Commonwealth has. It's just easier for us. If I'm up on a cross-examination or Mr. Yannetti is up on a cross-examination and we say, okay, if let's say we've got internal bait stamps that show photograph number 231, he'll know what photograph number 231 is. He'll have an outline that tracks our cross-examination or a direct examination.
So it will be only things that are in evidence or will be coming into evidence. You're not going to do that with disputed?
Absolutely not. We would never do that. If there's anything that's disputed or
We'll go to
even
sidebar.
remotely controversial, my habit and practice is to ask to approach the bench. We all walk up. I say, this is what I'm proposing to show the jury, and the court rules on it. But no, all it is just a...
Why is there such a big
sort of
sigh?
a facile accommodation of...
I don't know why this is even dramatic. In every one of these cases that we've watched, well, in almost every one, the defense team has somebody helping put up the exhibits or the prosecution. Like, this is not, I don't know why the judge is like, just have somebody put the exhibits up. Sometimes it's a paralegal. Sometimes it's another lawyer. But that judge sounds done. This is
seamlessly showing...
This is not weird. I mean, I get we're at the end of like an hour and a half hearing.
Or playing a video for the jurors.
All right. What's the Commonwealth's position on this?
Who cares?
Your Honor, given that representation, I mean, that's precisely what we do in every case in which we have either Ms. Gilman or Ms. Crawford or whoever.
That's what tech people do.
Assisting with the trial. If that's what it's limited to, I don't know. About the additional monitors or things of that nature, whether or not, especially if we're going to be in courtroom 25, whether that's really necessary. But certainly whatever logistically we have as far as
it looks like this courtroom
or screens or whatever.
It looks like this courtroom has already been this courtroom layout's weird, but it looks like this courtroom has already been outfitted with temporary cameras. So it'll be interesting if they're moving the courtroom.
Is obviously fully, we would fully make accessible to defense counsel as well, as we do in every case.
All right. So, in Suffolk County, there are monitors. The audiovisual equipment is fantastic. They're at the jury seats. They're for everybody to see. There's even a way if something is an objected to motion, it can just be seen on the lawyer's screen and the judges. So the bottom line is, if we had known about this 2 months ago, we would have been able to really put the time into seeing exactly how this works. Ms. Giannetti, I'd like to finish first, and I'll give you the opportunity to speak to
It's odd to me
Mr.
this
Jackson,
is an issue.
to really see how this works, see how we set it up. I can't devote that time to it right now. No monitors, I don't want a monitor. I'm not allowing, or Madam Court Reporter is fine. We're in that very small courtroom now at your request. So we don't need monitors on the tables. I don't have the time to physically go see how this all looks. Ms. Gilman's here. Perhaps she can speak with your audio-visual person, and then you can all make a presentation to me. But again, this, months ago would have been much better.
Well, I understand the court's concern. This is extremely modest, and it's not going to take a whole lot of presentation.
I don't understand why this is an issue. I'm really confused why this is an issue.
I don't want to monitor.
I don't know if I want monitors on those tables so close to the jury.
That's fine. Then the court can say, I don't want monitors that close to the jury.
She is saying that, though.
What I would do is just use paper copies. When I'm up on direct or cross-examination, I don't want to I can't prepare with the Commonwealth's.
No, I understand that. I don't think he'll fit at counsel table.
I can't speak to that. I think he would. I think we could accommodate him. Or if he doesn't fit right at counsel table, we've also set up. He was on a relatively large case that we had in a small courtroom back in California, and he's set up just behind counsel table, and he's got his own laptop, and nobody else can see it. And he's got a type of screen that you can't see it from angles, so jurors are not going to be seeing anything. But I need to be able to, and Ms. Little and Mr. Giannetti need to be able to prepare with him. And I think the court.
No, I understand that. I don't have a problem with that. It's the 4 monitors on the tables, one on the bench, one for the court. We're in a small room.
We won't do that.
And I'm concerned about the amplifying sound. I mean, is it like movie theater sound? I mean, it's, again, a tiny room at your request.
He uses very modest speakers.
She is not happy with them. She has said it like 4 times. We're moving courtrooms at your request. We're going to a small courtroom at your request. And it was at his request. So I guess they're moving courtrooms, but now I'm deeply invested into why the tech is a issue. But they're going to be playing interviews and video. How the jury hears those is very important. Just very important.
Appropriate for the space. So for instance, in this space, it would be probably a couple of speakers that are larger so that the jurors can hear, or the court can hear. In a small space, he'll just pare it down and use small speakers. And there's a switch. So for instance, he will work with Commonwealth's AV expert, and there's a switch on both tables.
You have all day tomorrow to do this.
My turn, switch, and now.
All right,
like it's Thursday.
So is that switch, are you putting wires? I mean, these are all the things that I shouldn't be dealing with.
She's mad that it didn't come up sooner.
We just got Wi-Fi in this building a week ago. I mean, it's not a building that.
I understand.
We can just last minute. It's a beautiful old.
Patricia's like, this courthouse just got Wi-Fi. She said they got Wi-Fi last week. It is a courtroom that's like over 100 years old. It doesn't seem that she's thrilled in the small courtroom. No, but then she has to move all her shit too, which for judges is real frustrating.
Historic building. We want to keep it that way. So
it's a historic building. We want to keep it that way. I don't think they're proposing drilling holes in anything, Your Honor. I think they just need to run a wire to a speaker, though.
We will not mess anything up.
Lawyers hate tech, though.
I was told that by the Commonwealth.
Judges double down on that too.
Which is, consistently. That's not new technology. It's very simple. It just allows.
Simple or not, the judge feels like it's being sprung on her at the last minute and is mad.
Both of us.
I don't care how simple you say it is. The judge is not pleased.
Visual portion of the case more seamlessly. That's all. We just want to make it.
Easier
and more professional for the court and for the jurors.
So it would be during your case in chief.
It would be during my cross-examination of every one of the witnesses. I mean, the bulk of the case is going to be the Commonwealth's case in chief.
All right, with exhibits that are already into evidence, you're not trying to enter exhibits during cross-examination?
I mean, unless
they're in evidence
that I didn't see coming. But even in that case,
They would
my
approach.
habit and practice, my custom and practice would be to approach if it's a matter in controversy, or tell the
It
Commonwealth
feels like we have a little bit of distrust.
in advance, I'm about to show this photograph. Do you have any issue with it? No, I don't. And then we'll show it. But I would
The things that Attorney Jackson is saying at the moment is just like how it works. Like, it's just how it works. If something's not in evidence, you ask, and you ask the other side. I don't know why this is a problem.
never. The point of it is not to ambush anybody. It's just to make what is going to be shown and what's allowed to be
Easier.
shown seamless and more professional looking.
Does the Commonwealth and Ms. Gilman have an opportunity to spend a little time today to take a look at it and see? I mean, everybody's preparing for trial, obviously. Again,
Take a
this
look at
is,
what the computer?
I don't have the time to do it, and I understand if you don't, but
I think Ms. Gilman can spend some time. She actually had made arrangements to meet Mr. Bates here last Friday, and he didn't appear when we were told he was going to be here.
That's not delightful.
But I'm happy to have Ms. Gilman.
Ms. Gilman, are you willing to spend some time today?
That looked like a yes.
By the way, just Mr. Bates's defense.
Oh, dear.
Yes, he was supposed to come last Friday. He was told he couldn't come because he hadn't gotten permission from this court yet.
Okay.
We did not.
Well, that makes sense, frankly.
I just don't want there to be a sort of a hanging chad where that's concerned.
Really? It's so odd to me, this courtroom layout where the prosecution is sitting at a table in front of the defense and not side by side. But again, I realize this is an older courtroom, but I have not seen a courtroom laid out quite like that. It's laid out. It's a strange
Well, especially
layout.
where he didn't start out well, right? Being a counsel table during impanelment.
I understand that. And he's been told that was inappropriate and obviously would never happen again.
Okay,
All
well,
right.
that explains why the court is
some
mad.
Sort of ground rules. Only one counsel, whoever's doing the cross-examination of the witness, objects.
Yeah, one witness.
Just one, not all of you. It's not a tag team. So one person objects. If you want to approach the witness, you must ask permission.
Rules.
At sidebar, there will only be one person talking again, and it'll follow with whoever does the
One witness, one
examination.
lawyer. That's fair.
Many times I allow counsel to discuss things, and many times I call directly on maybe appellate counsel or counsel who's been the big law person. So you can ask me for permission for that, and no basis for your objection. You just simply object. That's it. And if we need to see you at side,
Mickey Marie, the woman in red, is the court reporter, and that is I forget what the proper word is for the oral stenography, but instead of typing on a machine, they do stenography verbally. So that was the same type of stenography that we saw in the Murdaugh trial.
sidebar, we'll see you at sidebar. But I don't want a
Less
whole litany
physically
of reasons
difficult,
why
I would think.
the testimony you think is
Thank you, Lyndon said
inadmissible.
it's a steno
So those are
mask.
pretty standard rules. I'd like to see counsel at sidebar regarding a jury issue.
All right, they're going to sidebar. I really wanted to get to the part of this where we heard about the other courtroom. That is really the end of the hearing, but I really did want to hear about the courtroom more than argument over the tech person. So I'm going to see if I can back up and get to that part of the hearing. No speaking objections is good. I'm here for no speaking objections. I'm here for no speaking objections. And what that means with no speaking objections is that
all of these issues were explored in
the objection would be hearsay, and that's it. Yeah, I need to back it up. I think it was before I started. So I'm going to back that up a little bit and try to find it.
that particular area. And just because counsel, I think, may not like the answer or doesn't believe that the answer is truthful or whatever, that does not then permit bringing in this witness to testify to what they know.
Okay, that's still about the witnesses, which I have heard them argue. Let's see.
Statements and why he made those statements. And also,
That's not about the courtroom. All right.
We had our motion in limine hearing. I think we went much of the day that Friday. I don't remember if it was last Friday or the
Oh, I've got to
Friday
back up more
before.
than this.
I ended that with saying twice, is there anything else
Okay.
we need?
That's where we started. So I need to back up more than that if they're talking about the courtroom. Though it seems that they're moving it, so maybe we just don't get there and that's fine.
That's fine. I can handle that. Regarding the
It's fine.
animosity, again, it's close in time. It goes to the nature of the relationship. I will give a limiting instruction. I'm confident that the limiting instructions will be followed by the jurors, that they're
That's
understandable.
regarding-
I will make observations at the time, and if they appear to be understanding and nodding, which you often see on limiting instructions, I will make those findings as well. But I'm satisfied that the jurors will be able to understand the limiting instruction.
Linda asked, why the objection and not the basis? It's the objection and the grounds, and that's it. And then if the judge needs to hear more, they'll bring the attorneys up at sidebar, and it's to counteract everything you saw in the Rust trial where the attorneys were just yelling shit out and over each other. It's literally objection, grounds for objection, and nothing else, which is appropriate, versus objection, Your Honor. They can't even testify to that. That's completely uncalled for. And with the presence of this jury, those types of objections, objection hearsay, objection foundation, objection motion in limine, which is not really an objection, but objection, outside the scope, whatever. There's no just blurting things out in front of the jury, which keeps a case tighter.
And use the testimony only for the intended purpose. And the animosity goes to the nature of the relationship.
Okay, that's
being
from
the
earlier.
woman's testimony regarding ending the relationship. Again, that goes to state of mind, and it goes to the Qualls and Bins line of cases. And I will give a limiting instruction.
She said no
I'm
speaking.
confident the
She's going to
jurors will
have to hear the
understand.
grounds, though.
So that's my ruling on that.
I'll go look.
which
I'll go
actually-
listen back.
So it would be a denial, Jim, of defendant's motion 283.
Just for the record, it's 282.
82.
Oh, it happened in Murdaugh. It happened in Heard. It
and-
happened in.
And that's
It happened in a
denied.
lot of the trials
It will
we've seen.
not go to propensity, and we can make sure of that. And the Commonwealth's motion
I just want to hear about the.
is 310, Jim, the bold 20. And
No, can we just? I just want to hear about the.
that was sort of hand in hand with the other one.
I just
All
wanted
right.
to hear about the courtroom.
So moving on to, I think we just briefly talked about, so it's paper number 306, Commonwealth's motion in limine to admit expert celebrate demonstration. I think we briefly,
If they didn't talk about it, I know. Well, she talked about it, saying that they're going to be in the new one. So some of you guys have already heard this. She doesn't talk about it. They decided that they're moving it. So, that's happening. Did not hear what she said about grounds, so I will go back to right before she called for the sidebar, and then we will zoom right out of this and finish up questions for the day as she finishes up the housekeeping matters, and then we're out.
whoever's doing the cross-examination
So I'm gonna listen one more time.
witness objects, just one, not all of you. It's not a tag team. So one person objects. If you want to approach the witness, you must ask permission. At sidebar, there will only be one person talking again, and it'll follow with
That's fair.
whoever does the examination. Many times I allow counsel to discuss things, and many times I call directly on maybe appellate counsel or counsel who's been the big law person. So you can ask me for permission for that, and no basis for your objection. You just simply object.
Oh, she did say
That's
no
it.
basis.
And if we need to see you at sidebar, we'll see you at sidebar. But I don't want a whole litany of reasons why the testimony you think is inadmissible. So those are pretty standard rules. I'd like to see counsel at sidebar regarding a jury.
Interesting, because if the grounds aren't stated, it, I think, makes it a little harder for the appellate record, which means they're going to be going back and forth to sidebar a lot. She did say no basis. She said absolutely no basis, which I think would be very, very frustrating. But I think there's room for objection and then the grounds and then nothing else, it's going to be a lot of sidebars. It's going to be a lot of sidebars. That's going to take some time, but that's the end of the hearing. They go to sidebar and address other issues. Opening statements will be Monday. I'm going to answer a few questions and then we are going to zoom because then I have a few things that I have to finish. I know it's shocking. I have things I have to finish up before we start that so that the podcast comes out next week like it is supposed to. So let's do a few last questions. Why did my screen get all weird? Let's do a few last questions and then we will zoom on out of here to have the rest of our Thursday. It's been a busy one today. So there we go. Where did the rest go? This is going to be a long trial. The court days are not going to be super long, but it's going to be weeks and weeks and weeks of trial. So there is that. But the court days shouldn't be too long. We're going to have a couple of half days, no court on Friday. It's part of why it's going to take forever, which I mean is good for us, I guess. So they're going to be up at the bench quite a lot. It's going to be interesting. All right, let's get to questions real quick. All right, Leonard 6704 said, do we have a court date yet? Monday for opening statements. And it looks like they're on track for that because the jury has not been sworn, but they have been selected. The arguments that happened in court today and the motions in limine are done today. So that's what they're doing. Lori said, are they really only having 3 trial days a week? Mm-hmm. So far, that's what they've said. I don't know if that's going to change, but so far, that's what they've said. So, yeah. That's part of why it's going to take so long. But it should limit arguing on things like evidence and the rest of it until later. I don't know exactly what time they're starting on Monday, but I will let you know in the Leonard app when Valkyrie Arts, when I know what time we're starting Monday, I'll let you know in the Leonard app. Every time I've popped on this court hearing, they've been like 45 minutes late to start. So I feel seen. And so I will let you know in the chat. Hi, Leonards. Tough day with an anniversary day. Sorry about that. Keep talking about mental health. Glad to be here. I mean, it helps, I think, always to chat. So let us continue on. Gunslinging led to mudslinging. Lori, thank you so much for that. The lawyers in the Baldwin case are not going to quit. They're not going to quit. Lynn said, EDB, did you watch any of the Elias Hooser manhunt that started? No. Our local community is devastated by the loss and so many precipitating system failures. No, I have not seen or heard about it. So when things happen, communities are absolutely impacted. So I hope your community starts to recover. Jackson said, hey, EDB, love your stream. Shout out to my mom, who's also watching the stream. Love you, Mom. Jackson's mom. That's very sweet. There is a shout out. Reverse of Chelsea Mira's question. Can he appeal the California conviction based on the reliance on a prior conviction in New York that was now overturned? I don't know if Baldwin's team, or not Baldwin, sorry, Weinstein's team relied on the New York conviction. They were separate charges, separate victims. So I don't know if those convictions came up for anything other than sentencing, but the rules in California are different. So it doesn't kind of go that way the same way because they are different. And the rules of evidence in California allow for a different level of 404 evidence with regard to sexual assault. There are different rules there that carve out actual rules of evidence to allow that in. I see you. Thank you for the chat and the compliment. So, following up, a school official was arrested in my city for lying to police. Oh, that's not good at all. So I'm sorry to hear that. Jam Boy said there's an ADHD med shortage in the UK too. That's not helpful. Maury gifted 5 memberships. Thank you. Lindsay, question, are you attending CrimeCon in Nashville? Yes, I am. We will be doing a Leonard meetup. We are hammering out the final details of that to not impact the schedule CrimeCon has going on. Today, my kid's school approved his ADHD accommodations. Yay, Isabella. Congratulations. It's a lot. Jeremiah was a bullfrog. The chat was so swift with that. It just, Jeremiah is a common French expression, whining and complaining. It's a new one to me. Love to see it. Motion to pronounce list of woes as Joey Lawrence. Whoa. List of woes. Darcy said, friends, Romans, countrymen, lend me your ears. I hate these attorneys. They're saying shit that's not true. Motion to rename the pickle. We'll see. We've got a whole trial coming up. So I think the pickle's going to end up with names coming out of trials. I imagine that's going to happen. Emily said, it's amazing how birding creeps up on you. One day you're young and hot, and the next year in your 30s and really into migration patterns of the Western bluebird. It just kind of does. You know, when I moved a little bit more into the country, it was one of those things I'm like, Jess Slimmer said, I have surgery on Monday, so I'll be ready for trial while I heal. Thank you, Emily. Tomorrow is my husband and I's 19th anniversary. Happy anniversary. And yes, you will be ready for trial for sure. Samantha said, question, can the Gutierrez trial be brought up in Baldwin's trial? Yes, kind of. The testimony, if a witness testified at Hannah's trial and then they testify at Baldwin's trial and they say something different, it's going to be, the transcripts are going to come out. Didn't you say this? So yes, it will come up in that context, but the fact of the whole trial won't come up. The video from the trial won't come up, but a lot of the witnesses are the same. So their prior testimony will come up, but it won't be said what the prior testimony is for. Colleen, EDBQ for both cases. Why does prosecution not need to provide evidence for the origin of the live round? They believe that they did in Hannah's case. So, and I think they will do some of that again. As to the Baldwin case, it's not as relevant as it was to Hannah, but in Hannah's case, the prosecution believes that they did. Emily Outdoor said handshot first is my Wi-Fi name. It's fantastic. Mighty Wombat said this reads like a Reddit post. It's a lot. Rune says, was this response written by a lawyer who did the deposition on the cop that suspended license cases from a year back? I have no idea what that's referring to. I'm sorry. Clairol said, will the trial be televised? Yes, the Reed trial will be televised or streamed or available. Yes. Judge gives meaning to, we'll see. The judge sounded a little tired. We did come in at the end of the hearing. Judge is like, I'm busy moving my stuff. Moving to another courtroom does take quite a lot of effort. Santa Fe Courthouse was built in 1888. I wonder when that courthouse was taken. They don't talk about the courtroom. They didn't talk about the courtroom, or they don't talk about the courtroom. They decided it, which is good, I guess. They're moving to a different one. Alec Baldwin smacked the phone out of the hand of a protester the other day. I got tagged in that a lot across social media platforms. The defense is like, how dare the prosecution say Alec Baldwin have no control of his emotions? Also Baldwin. However, I imagine getting harassed and screamed at on the street is not ideal, but when you are a public figure, I think you often have to leave where you are at to leave the situation. A week ago, was on my way home from DMV in Australia. Amazing. Shaz, I bet it was great. Bev has heavy sighs constantly. I mean, I do too sometimes. So it seems like that's the norm for the judge. Is Jeremiah was here engraved somewhere? It should be. Rando from Iowa said, yeah, but the person was harassing him also. Yes, they were. I think you at some point, especially to be a public figure, you have to remove yourself. The people being harassed in public is a wild thing that seems to be on the rise. Like putting a camera in somebody's face and harassing them to see if they respond. Though I do think Baldwin at this point should know that people try to do that to him and either try to leave or I don't know, ask for help. But I've seen it in the Reed case too. I don't know why Karen Reed has to walk from the car to the courthouse. And it seems like enough of a way that there's like a mob around her and her legal team as they're coming in and out of the courthouse in a way that doesn't seem like it's going to go well as this trial progresses, but with people just screaming things at her. It's just a lot. And yes, there are, you have the right to scream at people in public. Do I think it's ideal? No. Do I think it's a good idea? No. Do I think there are some boundaries between free speech and harassment? Yes. So I think when you're Alec Baldwin and you know that somebody's recording you and you know that you have a trial coming up, that unfortunately, though it might not be the right answer, it might be the answer that you are the one who has to leave the situation, even if you're not in the wrong in that situation, because people are trying to escalate him. And that's something I think he's aware of, though I'm sure he's also exhausted with it, right? So it's just quite a lot. Rando says people have forgotten common courtesy and replaced it with wanting TikTok clout. It's a lot. It's a lot. And also the seeing the people just screaming at Karen Reed on the way into court and not even being able to drive her like behind a gate. In Depp heard they were able to drive into an area that was cleared where they could get out and go into court. It seems like a recipe for disaster in this trial that they have to walk across the street and down in front of the courthouse. It seems like a lot. Lisa, no, I understand why Baldwin was mad. I just think it puts him in a difficult position in public. But I understand why he was mad. I don't think people should be harassing each other in public. The Norfolk County Courthouse was built in 1827. Right? So with all of that, you guys, it has been almost 3.5 hours. I will see you on Monday for trial. Download the Lawnerd app. When I have a time for case, I will put it in the app so we will know when we are streaming. My words have stopped. We're about 4 hours in. That's about right. It's time for lunch. It's like 3:00. It's definitely time for lunch. It was a busy morning. I hope that today's episode helped you understand kind of what is going on with all of the things as we get ready for this trial. So we will be back in trial on Monday unless something happens. And if it does, I'll let you know in the app. Because when I went to post about the ruling in the Weinstein case today on Twitter, the amount of adult content responses under that reminded me again why I've stopped posting anywhere other than my app, because I went to try to respond to some of the Lawnerds that were asking questions and I was like, oh, wait a second. The replies are naked. So and that's a lot under especially that type of a post. So we will be keeping most of those updates to the app, because really it just is what it is at this point. The replies are going to be in the app. Most of the things that I keep you guys in the loop of are going to be on the app. I've kind of reached the point where I'm just done. So in the app and on Insta is kind of where you will see me most, but in the app primarily, that's really what I have the energy for. And then here on YouTube, and I will update things in the community tab as best I can. App first, which is available for free in all of your app stores, then community tab, then Insta when I can. That's kind of my order of importance as we get into trial. I hope that helps. I hope today's episode helped. And with all of it, Law Nerds, thank you for being here. Mods, thank you for riding. Everyone, thank you for hanging in for a long stream today. We're back in court, so I'll see you on Monday, and we're going to be spending some time in Massachusetts. All right. Y'all have a great weekend, and I'll see you soon. Bye.
You can stay up to date with everything I'm covering and fast notifications on our free iOS and Android app at lawnerdapp.com, or search the App Store for Law Nerd. You can also follow me around social media, and don't forget to check out my podcast, The Emily Show, with quick bits dropping every Monday, summarizing everything I do here on the live streams on Tuesday and Thursday for when you just have time for the quick bits. Thanks for being a Law Nerd.